Until 2022, the law in England was irretrievable breakdown of marriage on account of cruelty, desertion, etc., which is very similar to our law. So, my lord, that what my lord put to me, that proposition, that's exactly the proposition that I'm advancing, that irretrievable breakdown of marriage can happen with cause, but it is still irretrievable breakdown of marriage for which a decree for divorce should be granted. So that distinction, bear in mind the three different types of reasons. Yes. Now, my lord, the Law Commission reports are there for what they're worth. I don't think they add too much. Let's just look at the judicial trends. Well, this judgment at paragraph 15, I would like to read it because it does contain valuable, a valuable discussion on irretrievable breakdown. Yeah. Well, this judgment, 2006, 4 SCC 558.
You have extracted, I think, the paragraph on the next page. Either you referring to something else or the paragraph on the next page?
I have. So I could turn the page over.
Yes.
But surely the entire judgment is very interesting.
Part of the compilation.
It is, Mr. Giri has filed the compilation, and in the compilation it's at page 108. I have extracted. Once the parties have separated and the separation has continued for a significant length of time, and one of them has presented a petition for divorce, it can well be presumed that the marriage is broken down.
Huh? Is 108?
Not what we are page 108 of the compilation. Lordship may turn to paragraph 66, 72, 74, 76. We begin with 66.
Probably what you are reading is at 129, madam.
Achha. You're right. Turn to page 128, para 65. The heading is irretrievable breakdown of marriage. Irretrievable breakdown of marriage is not a ground for divorce under the Hindu Marriage Act 1955. Because of the change of circumstances, for covering a large number of cases where the marriage are virtually dead, and unless this concept is pressed into service, the divorce cannot be granted. Ultimately, it's for the legislature whether to include irretrievable breakdown of marriage as a ground for divorce or not. But in our considered opinion, the legislature must consider irretrievable breakdown of marriage as a ground for divorce under the Hindu Marriage Act 1955. It follows Milan also on the Special Marriage Act. Then 59. 69. In the report, it is mentioned that restricting the ground of divorce to be a particular offense or matrimonial disability causes injustice to those cases where the situation is such that although none of the parties is at fault, or the fault is such a nature that the parties to the marriage do not want to divulge it. This is the other very important issue here. A person may be really suffering a lot of humiliation, but they don't want to put it in the public domain as such. Yet there has arisen a situation in which the marriage cannot be worked. The marriage has all the external appearances of a marriage, but none in reality. As is often put wittily, the marriage is merely a shell out of which the substance has gone. In such circumstances, it can be stated there is hardly any utility in maintaining the marriage as a facade when the emotional and other bonds, which were the essence of the marriage, have disappeared. It is also mentioned in the report that in case the marriage has ceased to exist in substance and in reality, there is no reason for denying divorce. Then the parties alone can decide whether the mutual relationship provides the fulfillment which they seek. Divorce should be seen as a solution. Well, a very interesting sentence. Divorce should be seen as a solution and an escape route out of a difficult situation. Such divorce is unconcerned with the wrongs of the past, but is concerned with bringing the parties and the children on terms with a new situation and developments of working out the most satisfactory basis upon which they may regulate their relationship in the changed circumstances. 72. once the parties have separated, the separation has continued for a sufficient length of time, and one of them has presented a petition for divorce, it can well be presumed that the marriage is broken down. The court, no doubt, would seriously make an endeavor to reconcile the parties. Yet, if it is found that the breakdown is irreparable, the divorce should not be withheld. The consequences of perseverance in a preservation in law of an unworkable marriage, which has long ceased to be effective, are bound to be a source of greater misery to the parties. A law divorce based mainly on the fault is inadequate to deal with a broken marriage. Under the fault theory, guilt has to be proved. Divorce courts are presented with the concrete instances of human behavior as they being the institution of bring the institution of marriage into disrepute. We have been principally impressed by the consideration that once the marriage is broken down beyond repair, it would be unrealistic for the law not to take notice of the fact, and it would be harmful to society and injurious to the interests of the parties. Where there has been a long period of continuous separation, it may fairly be surmised that the matrimonial bond is beyond repair. The marriage becomes a fiction, though supported by legal tie. By refusing to sever the tie, in such cases does not serve the sanctity of the marriage. On the contrary, it shows scant regard for the feelings and emotions of the parties. Now, Milord 76 is important. Public interest demands not only that the marriage status should, as far as possible, as long as possible, whenever possible, be maintained. But where a marriage has been wrecked beyond the hope of salvage, public interest lies in the recognition of the fact. That, Lord, was the Central England judgment that I cited, that there is a competing public interest, if I may put it that way. There are two public interests, but both are in public interest. Since there is no acceptable way in which a spouse can be compelled to resume life with the consort, nothing gained by trying to keep the parties tied forever to a marriage that in fact has ceased to exist. Now, my Lord, if you turn to 131 and paragraph 82, this is the extent of litigation.
17 litigations against each other.
And that is, of course, the law.
Good time for lawyers.
Etc. My Lord, yes, paradise for lawyers, I suppose. No doubt about it.
No, because they become standardized. Most of them are really, when I say Mukesh, because it's like a standardization. The moment a divorce petition starts, there may be dowry cases, there may not be dowry cases. But everything is like a standard format which happens.
Well, let's not talk about how the legal profession handles these cases. I can tell you, Lord, I was beyond words. I was shocked when I was handling a bail petition in an honor killing case, and I read the application for bail. Well, the bail was being asked for a woman who is 69 years of age and a housewife, and the bail petition read the woman is. It was like she's a working woman, and refusing to grant bail will affect her employment, and so on and so forth. Cut and paste taken from some other petition and seriously presented to the court.
Court is also confronted with situations that real cases, dowry is a factor of society. In cases that every family member is broken. So somebody who is supposed to be a sister-in-law, but he's staying anywhere in the country is broken. So this almost become a standardized format. To prevent giving maintenance, every woman becomes earning member, is doing cooking at his home, and doing cooking and selling, and every husband runs into a penury the moment a divorce petition is filed.
Very well for the legal profession. These are not legal. Well, I've done this case in the Supreme Court of India. The case I'm talking to you about, well, the matter came in appeal to the Supreme Court, and I just told that I'd read the bail application. It's 69-year-old woman, and this man was talking about how she has to go to work every day. At that point of time, she was actually in custody, and the bail was unfortunately granted. But that's a different story. I have no regrets about the bail. But at least pleadings should be proper. That's all that I'm arguing. It's not this cut and paste manner of pleadings, And yes, I have to say, I've seen it very often in matrimonial cases. I have not seen it very often in commercial cases. Well, somehow people don't seem to pay any attention to matrimonial litigation at all. I don't know why. I'm not able to understand the reasons for why this cut and paste happens.
I see. Sometimes the structured fees come in later in the matrimony.
I don't know, Millard. Maybe there's not enough money in matrimonial litigation. I have no
Zoning
idea.
is something. Unfortunately, land acquisition, for excess claim tribunal, and very, very unfortunately, matrimonial matters have fallen prey to chapter.
Millard, at para 83, even at that stage, opponent does not want to divorce by mutual consent from the analysis and evaluation of the entire evidence. One more passage from this judgment. 84. The High Court appreciated that there is no acceptable way in which the parties can be compelled to resume life with the consent with the consort. Nothing is gained by trying to keep the parties tied forever to a marriage that in fact has ceased to exist. Then 86, Lord, in view of the fact that the parties have been living separately for more than 10 years, the number of performance of criminal have been initiated against the appellant, and some proceedings have been initiated by the appellant against the respondent. The matrimonial bond between the parties is beyond repair. A marriage between the parties is only in name. The marriage has been wrecked beyond the hope of salvage. Public interest and interest of all concerned lies in recognition of the fact and to declare defunct de jure what is already defunct de facto. To keep the same in the obvious conducive to immorality and potentially more than the dissolution of the marriage bond. Then, my Lord, 89, in our considered view, looking at the particular facts of the case, the High Court was not justified in setting aside the order of the trial court. In our opinion, wisdom lies in accepting a pragmatic reality of the life and to take a decision which would ultimately be conducive to the interest of both the parties.
Then page 90, para 91 doesn't stand implemented. Para 91.
Yes, the 90th part of the case on constitutionality of the facts, this court would like to recommend that the European Constitution the Breaking Amendment incorporate irretrievable breakdown of marriage as a ground for ground.
Court did make a recommendation.
This judgment comes in 2006. Maybe that's why during 2010 and 2013 we did see two bills in Parliament. But they were patchwork. They did not achieve the end that they were. My Lord, however, I want to reiterate my submission. You know, these judgments do fail to distinguish between a divorce with cause and a divorce with fault. Now, my Lord, I'd like to just point out to a particular provision given the Hindu Marriage Act. Lord, what do we mean when we say fault? That's the question. So, my Lord, if your Lordship sees section 23, my Lord, the fault theory comes only in section 23 of the Hindu Marriage Act. Lord, my submission is that section 13 grounds of divorce are not really based on fault theory. They are based on cause theory. Lord, if you see 23 of the Hindu Marriages Act, decree in proceedings, in any proceedings under the Act, whether defended or not, if the court is satisfied that any of the grounds for granting relief exist, and the petitioner, except in cases where the relief is sought by him on the grounds specified in subclause A of B or subclause C of clause 2 of section 5, is not in any way taking advantage of his own wrong or disability for the purpose of the relief, and where the ground of the petition, the ground specified in so those are not mental incapacity, etc. Then in such case and not otherwise, the court shall grant the relief. In other words, my Lord, it is this section which brings in the fault theory, not section 13 of the Hindu Marriages Act. That is the proposition that I'm advancing, my Lord. So, my Lord, this is more, this fault referred to over here cannot be equated, my Lord, with the cause in section 13 of the Act. That is my interpretation of this statute. So, my Lord, perhaps it would help if your Lordship could think a little bit about and articulate this proposition, that what exactly is the meaning. Although, my Lord, yes, the recommendation of this court also has been that you delete section 23 of the Hindu Marriages Act.
No, under section 23, disability is attached to person who goes to the court, because it is based on well-settled legal principle that person who has committed wrong should not take advantage of his own wrong.
The theory of coming to court with unclean hands, etc.
That's the basic principle under
yes,
23.
it is referred to in some judgments also. My Lord, it's a principle. But two things you keep in mind. First and foremost, the heading of this section doesn't say decree for divorce. It doesn't. It says proceedings. And, my Lord, in actual fact, these provisions have sometimes been used when a husband wants a decree for restitution of conjugal rights, knowing fully well the marriage is broken down. It's standard practice when a marriage is broken down for any reason whatsoever. In order to defeat the claim of maintenance, what the husband will do, he'll file a petition for restitution of conjugal rights, knowing fully well that I don't want this woman back, knowing fully well she won't come back. Sometimes court grant decrees, sometimes court doesn't, then he goes for a divorce. But even that, some courts have held, even that is not taking advantage of your own wrong. So, my lord, what exactly is the meaning of taking advantage of my wrong? Yeah, that's why they distinguish between wrong and cause. There has to be some intent, some malicious intent, my lord, that my hands are not clean. But my lord, if I come to court with a case which is like a case and counter case, it can't be said that I'm taking advantage of my own wrong. So,
how would you categorize a case where actually facts of cruelty are found?
Yes.
Now, and that person who perpetrates the cruelty.
Facts are found because the trial has been gone through.
Trial has been gone through. So in the trial, it is established that there are various acts of cruelty, multifarious acts of cruelty. But yet, that very against the person claiming divorce, and that very person claimed default.
Yes, then I would say there is a public interest and public interest countervailing. Ultimately,
I'm going to fault theory. Will that not be a case of fault theory?
No, not because what is the
When you think,
that's why I said, let's go very logically. What is the
you
purpose
said
of
fault
marriage?
and
What
cause.
is marriage? What is the
saying-
purpose of keeping it alive?
I'm saying there's a fault and cause when you're making a
Yes.
distinction between fault
So
and
cause.
cause.
You can say there has been cause for the breakdown. You can say, and I'll point to one judgment where there was cause for breakdown at the instance of the wife, and yet the divorce was actually.
Those are, I'm saying, interactive reactions which produced a breakdown. I'm just saying only from point of view of saying that no fault theory is no role. The little caveat was that there may be cases where on evidence it is clearly established that the person suing for divorce is the one responsible for all that there is. Will that not also then fall at least within the fault theory?
No, there is. If you come to the conclusion that the marriage is broken down, there's no sense in invoking the fault.
I'm not disagreeing with it. I'm not completely not disagreeing with the concept that a good, bad, or indifferent reason for a failed marriage should not perpetuate that union meaninglessly. The thing is, you can take better care. You're talking about you can take better care for financial arrangements of them, and that's it. Maybe something more than a normal arrangement would be required because you did something to cause a break to the marriage. You are responsible. Okay, then you. You better pay more for the divorce.
I'm arguing that I may be responsible for the breakdown, but that does not disentitle me to the divorce.
But I'm saying this can be worked out, the impact can be worked out in financial terms in the court principle. What are the financial terms?
All you can do is attempt a reconciliation, even if I am responsible for the breakdown. But beyond that, once the factum of breakdown is clear, then it's like this. Somebody wants to keep the marriage together, not for the purpose of consortium. That is why I started my argument by saying, let's first understand what a marriage is all about.
That consortium is over, obviously. Whether A is responsible or B is responsible. If a consortium is over, we appreciate that argument. Once a consortium is over, then it's a pointless marriage, pointless association. So it must be. So if in a commercial terms, if there are two partners and the partnership breaks down completely and the trust breaks down, then the partnership gets over. You dissolve the partnership. Not sounding so commercial, but the fact is this: if a consortium is broken down and nothing is possible, there are cases where after difficulties also reconciliation takes place. But if nothing is possible, then but the terms of settlement may be accordingly.
The only reason to reject an application is if you come to the conclusion that the marriage is not irretrievably broken down. It has not irretrievably broken down. Then Yes, there is a purpose of keeping the marriage together. But if you come to the conclusion that it has broken down, it's irrelevant who was to blame. That's basically the issue, my lord. So therefore, my lord, let's not confuse this issue by reference to section 23, because section 23 is the that's why, my lord, I'm also going to say that the way your lordships have framed the issue under 142 also, your lordships have asked the question, can we do it when party is not giving consent? My lord, the question of consent is irrelevant. Ultimately, it's the court which gives a divorce or doesn't give a divorce.
That's a very expanded view. Why in the first two questions frame, we did not find this issue and we wanted to do is, because there were people who were raising an issue that even under 142 you can't do so. Therefore, we framed the question,
But I
can the
understand.
power under 142 be inhibited in any manner merely because it is not contained in the statutes? Prima facie, we thought may not, but subject to whatever arguments are advanced.
I understand that by saying the answer is yes,
The right to get divorced is a statutory right now.
it is.
And the fault is that of the person who says, I want to get out of the marriage. Then what do we do?
The only thing a court of law can do is attempt a reconciliation. Beyond that, my lord, no. Each other or live with each other.
You want to give full autonomy to the person to decide whether he wants to continue or not continue.
That is why I put it on the level of a fundamental right. The right to affiliate and the right to not affiliate. Subject to procedure established by law. Obviously, that is why, my lord, I started it saying because it's a judgment in re, the matter goes to court. There are systems of law where people give unilateral divorces. They exist, my lord. Even in India, there are systems where you can get a divorce by customary law without approaching a court of law, and the court of law will recognize that divorce. But there is an intermediary, in this case, the court. So the real question, my lord, your lordship have to decide is what exactly is the role of the court in a situation of this time. That's why I went back again and again and again to saying exactly what is the purpose of this arrangement. And your lordships have also said it in several judgments. So that's why if you just separate blame and fault, maybe that's one way of looking at it. And just separate. I may say, look, I know I'm blameworthy. But what can I do? I can't make a go of this marriage at all. I'm going to say sorry. The Indian law doesn't allow it. So, my lord, that's why in one of the judgments they say, look at the consequences of saying no. What are the consequences when a court says no? And, my lord, case after case, it's all in the compilation, my lord. Every case that has come before the court, the man or the woman has married during the pendency. I'll tell you the standard cases that come to court. A decree for divorce is obtained. Before the appeal period is over, one of the parties remarries. There's a child of the marriage. The court is presented with the fiat account. And then the appellate court feels that the original decree was bad in law. So there are reported judgments of this.
Then the status of the second woman troubles us. The status of the child troubles us.
And my lord, if I'm not mistaken, there's a judgment of they say, I'll dig it out and give it to you, where this court was compelled to hold that both marriages are legal. Lata Kumar. Just try and look for that case.
Right. One more question I have to answer at appropriate stage. There are cases and cases where this court has granted divorce by exercising power under Article 142, though one of the parties is not consenting. But these are all cases where there was already litigation, evidence reduced, and parties
Yes.
came to this court.
Yes.
Now, if we accept the argument that under 142, court can dissolve marriage when it comes to the conclusion, the irretrievable breakdown of marriage. So, will it be possible for anybody without approaching any court directly to come to Supreme Court and tell the Supreme Court that exercise power under 142? Because so far we have been exercising powers
Yes.
where there is adjudication,
And
there is evidence to come to a conclusion that there is a breakdown of marriage.
I'm not arguing that. I'm not arguing that point. Because it is.
But that will be a sequel. Somebody may say that, look, there's complete breakdown of marriage, therefore now grant me decree of divorce.
Go under 13B and file a petition for mutual consent. No.
No.
Indian law provides.
One of the parties, I'm saying one of the parties.
Where
One
there
of
is
the
no
parties said
consent.
that complete breakdown of marriage
Correct.
and grant me divorce. I am coming directly to the
Yes,
Supreme Court.
what I'm saying is,
But brother,
breakdown
there
of
is-
marriage.
There may be scenarios where society improves, gets better ideas from legal fraternity. So tomorrow somebody may say, look, why are you making this is torture? You're making me go through a process.
Can
I
happen, I
can't,
know.
so I can't go to court and say, look, I'm at fault, give me a divorce. Or I'm being unreasonable, but give me a divorce. So I will have to, unless the mutual consent, I will have to attribute things to the other partner to prove that she is in the wrong so that I can get a divorce. Why do you make me go through this process? My partner is unwilling for a divorce, but I can't live with her. And therefore, if I can't live with her, I don't want to make allegations against her. And if I don't make allegations, the divorce can't get through. So don't make me go through this torturous procedure. I'm coming to you saying, I may or may not be at fault, but I can't live with her. Please give me a degree of divorce.
There is an answer to that question, Manoj. You read the statute as a whole, and you decide whether the statute contains adequate remedies for a situation of that kind. How would a person approach the court? They would file an Article 32 petition, Manoj. They would surely. How do I even get to the stage of 142 without a proceeding? The proceeding would be either a trial court. That's why I give you the example. I filed a 32 petition in this court.
Somebody,
In a case in
The
which
indemnity-
there is no consent.
somebody like you will be able to guide them and tell them how to come to this court.
I can,
I will be dubbed an anti-marriage person. I won't do that. If somebody will say you're against the institution of
Actually-
marriage, I don't want that label.
I think actually, if you think deeper, if we take this, why I have to feel somehow the legislature has not done. What is the premise? Premise says, look, don't look to it as to what I have done or she's done. Good, bad, indifferent reason, I can't live with her. Now you work out the financial terms of my not living together. Let us somebody says, okay, I'll give 50% of my personal wealth. I married, didn't work out. I want to walk out of it. The system, unfortunately, at present is not providing for it.
Because one
Halfway houses,
get into the same.
ultimately you have to negotiate with the wife and get a consent decree. So now, of course, things are changing, society is changing, but sometimes you had a case of a person coming, ultimately,
But no
he came, he was, by the time he was 70 and she's 70 odd, so late 70s. Why do you want to divorce? He says, no, I don't want to carry this burden of the marriage. So what you do is, I don't want to carry the burden of the marriage. We've not lived together for 30, 40 years. Why do you want to remarry? No. What is it? I don't want to carry this tag with me.
I understand. But no, there are answers to that.
So many different scenarios which are possible.
Yes, it's different. It is different, my lord. And that is why this court has granted divorce by mutual consent, has allowed petitions under Section 13B to be filed directly in this court, but only where there is litigation which originated in the trial court,
So far, yes.
not directly in the Supreme Court under 32.
Even if one party has not agreed, divorces have been granted. I am party to those orders. Reasoning, I remember, Nagavattu argued a matter before me.
Well, not
Where
let me tell you,
granted
some of the
divorce,
issues
he
are
argued
going
that
to
you
come
can't
for
grant it
you.
without-
No, we were the Shiva Shankaran judgment, your lordship's judgment.
I argued that
Yes.
part of the company.
Yeah, it's there.
Divorce in that case.
But
I think it's 20.
Ms. Jai Singh also referred to that Shiva Shankaran judgment. Shiva
I
Shankaran.
think it's Shiva Shankaran.
Shiva Shankaran is already,
Yes. I had argued for Shiva Shankaran in that.
The compilation
Page
series, item number
222.
21.
Page 222, Manoj. Yes, there.
No. Yes.
Page 222, yes.
Sankaran. Yes.
Yes.
I remember correctly, Mr. Nagmuthu was one of
Yes,
the counsel.
he was on the other side. I had applied for the
You were on the
petition.
other side.
Yes, my lord. I was for the petitioner. This is the matter where your lordships were referring some time ago that the man had married in between and the lady wanted to continue the status despite the fact that the earlier marriage had failed.
Now that your lordship's on that, serial number 19 also,
Yes.
My Lord Justice Kaul was a party to the judgment, but the judgment was authored by Justice Shah.
Srinivas, that's
Serial
later.
number 19. Srinivas Kumar versus Shameta.
Samita.
Yes.
Yes.
Though there was no consent, but power under 142 exercise was granted, holding that as an irretrievable breach.
Well, look, that is why I said the question of consent is not relevant when a court is exercising power.
No, but we want to frankly settle the law because different views have been followed by different benches and the council still raised the issue. That you can't do. So only we can settle it first.
Yes, there are earlier views, at least two judgments, which says that if there is no consent, you can't grant it because you know irretrievable breakdown of marriage.
Well, look, that's
Let
the
me
advantage of being before a bench of 5 judges.
Absolutely, that's what I'm
Absolutely.
settling it so that this
One
divergence
is
is
that
another.
liberty to say that we don't agree with some judgments.
Even under 13B, after consent is withdrawn, orders have been passed.
Actually take you to the development of the law on irretrievable breakdown, even in the UP, at least common law countries, which we know that such a law exists. And we're not right up to 2022. So I hope I've made myself very clear. What I'm saying is there are always proxy indicators to whether the man, I'm calling them, for want of a better word, I'm calling them proxy indicators. So cruelty, or desertion, adultery, a separation for a prolonged period of time, litigation and counter litigation, these are all proxy indicators for the irretrievable breakdown of a marriage. That is the argument that I'm making, below.
Yeah.
So that is why I'm saying with cause and with fault are two different things altogether.
Understood. No, we appreciate what you say.
Yes, but just on an aside, it's not really, but since this question was put to me, that what if two people say we just don't want to live? I was going through Halsbury's Laws of England in a country which has a breakdown of marriage. Of course, my volume is very outdated, but your judge's library will have a more modern volume. But there is a entry under 417 which says the court must consider the effect of the respondent's behavior, whether such behavior is voluntary or involuntary, or the particular of the petitioner. It involves consideration not only of behavior of the respondent, but also the character, personality, disposition, behavior of the petitioner. A party's disinclination or boredom with a marriage does not entitle the court to give a decree. This in a country where irretrievable breakdown is. So, it's not. I'm not arguing. Tomorrow can say, look, I got married voluntarily, but I just don't like his face anymore. I wish my husband was more handsome. That's not the argument, below, that I'm trying to make. And that is why
You
I
have
said,
to check up before marriage.
yes. So that's why I'm saying just in law, distinguish between these two. Because the expression irretrievable breakdown of marriage is nothing more than a compendious expression which describes the state of the law.
Actually, if I might.
That's what it is.
That's
So we need,
an inquiry into an irretrievable breakdown of marriage. And that inquiry, in the absence of any other proceedings, I'm endeavoring to give an answer to my brother's question. Any experience here? Reasonable methodology. Solving a marriage without first being an inquiry. Right? For the fact-finding inquiry, the parties are contesting.
there is a
Therefore,
fact.
so that fact-finding inquiry will necessitate at least one court. Maybe this is where they said trial court has gone into a fact-finding, fruitless to go to the High Court. Then the High Court is also an appeal court on facts. So the only negative aspect of this thought process is, in the absence of irretrievable breakdown of marriage, you have to go through this process of fact finding and come here. But if we accept your contention,
Yes, it is.
then after that fact finding, it can be done at the first level, and after a second appellate find, it can be done. That's the only way I could think of constructing it.
Yes, my lord, it is, what I'm saying is parties need not have to wait for exercise of powers under 142. What I'm saying is if the indicators exist,
Yes.
if the indicators exist, my lord,
That
then it can be done.
indicators is an aspect of fact finding.
Yes, it is, my lord. And what is, actually they call it the duty of the court to attempt a reconciliation.
That-
Why? To give emphasis to the word irretrievable.
In fact,
Each
this,
word must be given its due
I
weightage.
tell you, this is one field of matrimonial disputes. There I'm aware of the Delhi High Court entries, where the pre-litigative mediation also takes place. I'm actually aware of cases where things have gone wrong, and I must say, I known people, I would say, please go there, Why don't you try it? And they have worked out a method of divorce, or they have worked out, most cases are working out this nitty-gritty financial which you are saying. Then look, two people can't live together, now what are the terms? So the mediator works out a viable arrangement for separation.
Look, but I must point out, there is one case of this honorable court, a rather unusual but interesting case, where the court granted a divorce on the ground of pleadings. The husband alleged that the wife was a serial adulteress. And the wife alleged that the husband was mentally unstable. And the litigation was going on. The trial had not taken place.
The two allegations against each other itself makes it an irretrievable breakdown.
Yes. On pleadings, the court came to the conclusion that this marriage is over. Lord, I want to read the judgment because it has a lot of interesting, whether one agrees or disagrees, well, Lord, that's really up to this court to decide. At page 47 of the compilation, the case is Bhagat versus Bhagat. I'm sure many of your lordships will know about this case already. Because it happened in Delhi. Basically, Milord, these are indicators. Started at the trial court, transferred to the High Court for trial, didn't work out, didn't succeed, transferred by the Supreme Court to the Supreme Court. And then the Supreme Court granted the decree because they said, look at the name. That these. So, my lord, first of all, you know, at page 342, internal 52, in the middle of para 7, your lordship will find that she reiterated that he was mentally unsound. At the end of the page, suffering from mental. And yes, Lord. And at page 53, she says he was a lunatic with a streak of insanity running in the entire family. And then, my lord, para 8, it is submitted that it is only trying to defend her honor. She was said, I made these allegations because of disapprove the unfounded allegations. This famous thing, it is said that marriages are made in heaven. It may be so, but this one has turned out to be a hell for sure. The allegations of the counter-allegations are indicative of the intense hatred and rancor.
You see, very interestingly,
any reconciliation is out of the
very
question.
interestingly, when you're reading para 8 on a factual matrix, just read the respondent has only been trying to explain that several serious products of sick mind and mere figment. He submitted that her children, even the sister and mother of the petitioner, are siding with her in this dispute, that the petitioner alone atoned from the entire family in prosecuting her. If the evidence would be led, all others would stand in the witness box in favor of her, who are relatives of the husband.
Yes, that was her claim. Then, my lord, at page 10, but none of these were subjected to any scrutiny.
Yes.
Page 10, para 10.
Whether you prove or you don't prove, if this is the feeling towards each other,
Yes.
you are right, what is left of it?
So it was an indicator, my lord. It was an indicator that what.
The indicator, there's a case you sent to a mediator, actually. Most times this was not so active. You send it to a mediator that, look, if they stick by these allegations, then what is left in marriage?
Yes. Yes, very, Lord, if I may say, this court appears to have a trend in which they encourage compounding of offences under 490. Though under a different procedure court, it's not a compoundable offence. Now, my lord, I take it that the policy behind that is to see whether things can be settled by the ending of that litigation, where parties have agreed that people settle the dispute. We do not believe that criminal litigation should be initiated in order to settle a dispute. But I can tell you that absent a regime of matrimonial problem, women have no choice. Why? Again, one day that case will come before your evidence. We're not trying to fight it for a very long time. What is the validity of saying? How does one interpret the Hindu Marriage Act on the question of alimony? What exactly does it mean? Does it mean that you're willing to give equal distribution of property acquired at the marriage? You will see a that are
holding the very apart from in the back of the mind there is do so say he goes into penury, he doesn't earn anything, nothing happens. The wife will make reverse allegation saying all the wealth of the family, everything is owned by him only. So, in absence of probity or issues of evidence, to do some kind of some interest. There is no other option. In the same way as maintenance, you have to look at the income tax return, but you also know that sometimes these are not reflections of, so while even granting interest, there is some value judgment which we have passed, or some kind of, where we say, no, this man must be, this is his assets broadly in the field, he must be worth. Go by income tax return. I've lost my job. I've had no reverse ladies saying, look, qualified ladies saying, I've given up my job, I don't want to work. Now give me on the basis that I don't want to work. It's also not an acceptable situation. So, social issues.
Well, at the end of the day, it's very difficult to sit in judgment over what goes on inside the home of the marriage. It's very difficult to say you are at fault, or even to evaluate their behavior. So much is a matter of personal perception. That's why it's this is a relationship in the realm of the intimate.
You can't say where it began. Very difficult to pinpoint where it began. Maybe our perception, maybe A has done it, but the fact is that B may have said something or done something which may have triggered it off. The trigger continues. Nature is everything is behind. Ultimately, the relationship is broadly behind four corners of the house and the closed door. You're not going to find.
So, Milan, I'll quickly finish with.
But in this Bhagat versus Bhagat, madam, in Bhagat versus Bhagat, the court dissolves the marriage on the ground of cruelty. Have you seen that?
Yes.
In Bhagat versus Bhagat, court records a finding that there is cruelty. And under section 13, the marriage is dissolved.
Yes, my lord, yes. And that is actually something that I would commend for acceptance, my lord, in the sense that you don't really need 142. And that is why the question of consent is totally irrelevant, my lord. It's totally irrelevant. Because at the end of the day, the judge is the arbiter of that dispute. There's always going to be lack of consent, always, invariably. But how do you deal with a situation where there's lack of consent? Ultimately, someone takes a decision.
It's a matter.
Everything is changing
This
to the
matter was
extent.
reviewed in person by reasonably eminent counsel himself in his own case. The Bhagat person.
In the High Court, not here, in the High
not
Court.
in the High Court, it was argued. it's a well-respected lawyer's case and both sides well-respected.
Yes, they do. My lord, but one essential safeguard, and I'll leave it at that. My lord, even this judgment actually, let me tell you, my lord, how I see the issue. There is no time to explain it, but I will put it in a few words. My lord, it is like
Yes.
my lord, as I see it, and this judgment has glimpses of that argument, and there has been an evolution of the law on how you interpret cruelty at all. And I'm suggesting that we interpret it more and more liberally. It is not cruelty in the sense of torture, etc., etc. No. So, and there is a discussion in this judgment of how the legislature, while amending the Hindu Marriage Act, in 1976 dropped some words such that it's impossible to live with the other party. Those words were dropped. Those words existed in a decree for judicial separation. So the suggestion that I'm making is there's been an evolution of the law relating to how to interpret cruelty as well. The Lordship will see that, my Lord, at para 40.
The vintage of time of this case was a little different. So society evolves. Today it's gone further on. But even then, while granting on cruelty in para 21, an ultimate paragraph.
Yes, my Lord.
So
And my Lord,
that
I
said
really
that,
would like to commend
though
this.
though it is on the theory that
Para 21,
while
22 are
scrutinizing
very,
the
very important safeguards while granting a decree. May I read them, my Lord, with some emphasis, with all the emphasis at my command. Before parting with it, I think it's necessary to append a clarification. Merely because there are allegations and counter allegations, the decree for divorce cannot follow. Nor is a mere delay in the disposal of divorce proceeding itself a ground. There must be really some extraordinary features to warrant grant of divorce for the basis of pleadings.
yes.
Not divorce on the ground of irretrievable breakdown.
Okay, and other admitted material.
Admitted materials without a full trial. Irretrievable breakdown of marriage is not a ground by itself. A lot of emphasis on the word by itself.
Yes. Now, next sentence is important.
But while scrutinizing the evidence on the record, determine whether the grounds alleged is or are made out and are determining the relief to be granted, the said circumstance can certainly be borne in mind.
That's what I said.
The unusual step as the one taken by us herein can be resorted to only to clear up an insoluble mess. The court finds in the interest of both parties. Now, my lord, I want to just point out 22, the petition for divorce pending in the Delhi High Court is withdrawn to the file of this court and is allowed. The allegations leveled by the petitioner against the wife are held not proved. The honor and character of the respondent wife starts vindicated. My lord, I commend for your lordship this formula for acceptance in cases where your lordships have come to the conclusion that the marriage is to be broken down. Because it's also necessary.
So that certainly you take it if we accept the principle and we have been following it and will be followed and in some way expounded by us. That when we are doing so, we are saying that things have not worked out. We are not attributing anything
Yes,
to
so the
anybody else.
decree should not result in any civil or criminal consequences for either party.
Often, where divorce cases, how do we do it? There are divorce cases already pending, not a mutual consent, with allegations. Taking the application of mutual consent in, that petition shall stand withdrawn. All allegations stand withdrawn. So that first chapter is the whitewash of the allegations. And then the power is exercised.
That can
Quite a smith.
the parties agree to file under 13B, to withdraw all allegations and file under 13B.
No, even where we have exercised powers under 142, with one party not
That's happened.
consenting, we made sure that the allegations do not stand up.
Yes. That has also happened, my lord, in petitions in this court. There's a right. My lord, initially the only dispute was whether the 6 months waiting period.
That was a more limited. That's a more
Waived.
limited.
That was the only issue the court was considering. Then the court went on to consider whether the 18-month period you can grant a decree when one of them withdraws, but after 18 months. And those are the type of cases that came to the 142. But there are also cases of the 142 where divorces have been granted without the consent of one of the parties. And your lordship will find in this case, there is not even a reference to 142 in Bhagat versus. It's an ordinary matrimony dispute.
Because the decree was granted
On cruelty.
on one of the specified grounds in the Hindu Marriage Act, but yet in some way covering up the concepts of allegations. See, look at the time period is different, 94 and 2022. Huge social change, 18 years is a huge time for a social
28
change.
years.
However, we have to think of their, I think, ability to do innovative thinking when the society was different in 1990.
Yes, well, also, if your lordships are inclined to take the view that such decrees can be granted, obviously your lordship will put certain indicators in place
Yes.
and certain safeguards.
Yes.
So that's why I call them proxy indicators, that they are actually indicators which are telling you that the marriage is broken down. That's the way to look at it. Now, my lord, I would like to take you to paragraph 22 of my written note to give you the evolution of the law, because this is where I come to the conclusion that irretrievable breakdown is a compendious expression for divorce with fault. Now, my lord, let us look at what happens in other common law jurisdictions. Evolution of the law of irretrievable breakdown of marriage. In the UK, the Divorce Reform Act of 1969 introduced the language. My lord, please note, I'm being very specific with the use of my word. I'm saying it was the language of irretrievable breakdown of marriage in section 1 and 2. But look how it read. After commencement of the act, the sole ground on which a petition for divorce may be presented to the court by either party shall be that the marriage is broken down. Now, subsection 2. The court hearing a petition for divorce shall not hold that the marriage has been broken down irretrievably unless the petitioner satisfies the court of one or two of the following facts. That the respondent has committed adultery and the petitioner finds it intolerable to live with the respondent. That the respondent has behaved in such a way that the petitioner cannot reasonably expect to live. That the respondent has deserted the petitioner for a continuous period of not less than 2 years immediately preceding the presentation. That the parties to the marriage have lived apart for a continuous period of 2 years immediately preceding the presentation of the petition, and the respondent consents to the next being granted. That the parties to the marriage have lived apart for a continuous period of at least 5 years immediately preceding the presentation of the petition. A petition for divorce shall be the duty of the court to inquire as far as reasonably can into the facts. Every word is significant, and I would emphasize it. To inquire as far as it's reasonably possible. This raises the question of standard of proof, Lord.
Now, the condition is fairly stringent, because if you look at E and E, the parties to the marriage have lived apart for a continuous period of 2 years immediately preceding the presentation of the petition, and the respondent consents to the degree being granted. 1. Number 2, the parties to the marriage have lived apart for a continuous period of at least 5 years immediately preceding the presentation of the petition.
Yes, Lord.
It's fairly stringent.
See, when you talk about here under this act, irretrievable breakdown of marriage, you can only claim this in the absence of consent after 5 years.
Yes.
That's the little stringent condition.
All those waiting periods are put in the hope that there will be a reconciliation.
And there is another aspect to it. In that society, normally both the spouses are working. They work.
It's true.
It's the normal. It's normal.
Yes, working parents. Working
Indication from the
partners.
transfer petition letter here that
Hello. To be honest, this statute has undergone amendments any number of times, and some of these periods have been shortened, not shortened. The reason I put it on record is to show that despite the factors that exist, they use the expression irretrievable breakdown. So there's a lot of significance to that, my lord, that it is a factor to be taken into consideration when certain facts exist. And that's why I repeat, my lord, these are really only pointers to the breakdown.
So you think in the transfer petition, which we have seen, if I can say, more than 50%, then I would take that as indicators of failures of marriage, because those are coming being launched, are within the scope of 0 to 3 years marriage. It's a very high percentage of the petitions coming forth before the courts are in early years of marriage. I've seen same day, I've seen few months, I've seen few years, but a lot of them are in the range. I would say almost about 50% would be in the range of 0 to 3 years of marriage.
Yes.
So that's why when I looked at 5 years, I thought,
Unfortunately, in this country, there are not enough empirical studies. But in the UK, before they passed these laws,
must have done their own.
they commissioned Royal Commission reports on what are the patterns of divorce, what are the reasons, what are the causes, what are the consequences. But what happened here in 2010, we just introduced a bill in Parliament, Irretrievable breakdown, without any empirical data as to what are the consequences.
Empirical study we don't do. I've been emphasizing judicially legislative impact studies. Just bring in legislation without any legislative impact studies. It's a great problem. The consequences are felt after the legislation comes.
But, my Lord, with respect, I wish to say that the law in this country is changing. After the passing of the Prevention of Women from Domestic Violence Act, we now recognize non-banking unions as deserving of protection of the law. It says that it's an act which extends not only to married women, it extends also to people who are living in a relationship in the nature of marriage, which was intended to bring in civil unions or of a conjugal nature. And this court has explained what is the meaning of that expression, relationship in the nature of marriage, basically by saying there has to be conjugality. It's also changing. That is a very major factor, my Lord, that the Lordship will have to make. Indeed, I can make bold. Fire into the case so far as reasonably can. What is the meaning of this so far as you reasonably can? Because there's a point beyond which you cannot inform the case.
Personal.
Yes.
Can't get into this.
Yes.
Relationship.
And look, there is also case law. I can point to it. There was a time when judges were using proof beyond reasonable doubt in matrimonial proceedings in England. In England, it's there, all reported judgments for law. Then a court had to step in and say, sorry, matrimonial proceedings are not criminal proceedings. You have to use balance of probabilities to decide. That is why I'm emphasizing this word so far as you reasonably can. So, my Lord, really the suggestion that I'm making, which I will sooner or later put it into writing, is that give a liberal interpretation to section 13. Read into it irretrievable breakdown when you see certain proxy indicators. And, my Lord, the nature of the inquiry is on balance of probabilities, perhaps even a more liberal standard than balance of probabilities. I would recommend a standard of perception of the people. That's been done in the case of sexual harassment. That standard is used in law. Because somebody can say, this is my perception that it is sexual harassment, your perception is that it's not.
Yes.
It's a classical case, my Lord, in which perceptions differ. So, my Lord, if you use these three legal tools, a more liberal interpretation, the question of what will be, and a more more liberal interpretation of the standard by which evidence will be evaluated, where inter alia, my lord, your lordship uses the perception of parties themselves as a standard of proof of facts and circumstances, and then puts in place certain proxy indicators along with certain safeguards. I don't know whether this proceeding will indicate the precise parameters of financial relief, but that may have to await another case. The safeguard must be there.
We certainly will build into it the concept of a safeguard.
Yes, the safeguard that before any such decree can. So what I'm saying is, Lord, your lordship may not be able to give a measure of what should be given. For the moment, in my mind, I have only used the standard of living to which the husband is accustomed, which has been used in law. Until we see an amendment that says that matrimonial property should be equally divided. Honestly, my lord, I was looking at the statistics in. There is data of how many divorces are filed every year in the country. So, my lord, can reasonably can.
Some problem is there has to be commission documentation. There has to be some other methodologies to assist the court by producing. Yeah. And it's again what has to be done. See, I think sometimes everything lands in the lap of the court in the first instance instead of the groundwork being done. That's why we request amicus to assist us when we find that there are other assistants not working.
No, my lord. For example, this paragraph 6, I'm sure, has been amended or there is case law. But the purpose of this act, husband and wife shall be treated as living apart unless they're living under the same, each other in the same. So this is no longer the law. Now the law is you can live under the same household and still.
Live separately.
My lord, in this subsection 5, that what is the meaning of living apart? That means you have to be not in the same household. But this is no longer the law, my lord. You can be living in the same household and yet be living apart. Even this court has held that.
Yes.
Now, my lord, I come to my submission in 2423. From a reading of section 1 and 2 of the Divorce Reform Act 1969, it is apparent that the factors such as adultery behavior in a manner which petitioner cannot be reasonably expected to live with the respondent, desertion or at least 2 years, parties living apart for at least 2 years, apart, not less than 5 years, immediately preceding present, were all taken into consideration while deciding whether the marriage had irretrievably broken down. That's why I said these are proxy indicators. But what you're looking at is there a breakdown? What is happening today under our dispensation is people are not even looking at the issue whether there's a breakdown. It is thus submitted that the above factors are indicated. Now, my lord, comes to qualitative in the law. In 1973, UK passed the Matrimonial Causes Act. The Act continues to be enforced till date. However, the Act of 73 was further amended by the Divorce Resolution and Separation Act. But Section 1 and 3 read as follows. Subject to Section 3, either or both the parties of marriage may apply to the court for an order of divorce which dissolves the marriage on the ground that the marriage is broken down. This is not, now you can say it's a no fault claim. Court dealing with the application under subsection must state the statement to be conclusive evidence that the marriage is and make a divorce. Saying that ours is not system of divorce based on it is a system of divorce based on cause. But the ultimate decree reflects the fact that the decree for divorce. I'm sure that we may not be able to, I may not be able, perhaps I won't be able to persuade you that you should also take a statement. Because there is, at the end of the day, the judicial body looking into it. But here what they've done in England is, they've said no, either or both parties pay a
It's just taken them so many years to come to this stage. Yeah, also it will take time.
I was myself surprised, Lord, because of this confusion in the head, fault and no fault are the same, but they're
That
where you say
distinction
for
is obliterated there, but
yes, I'm surprised. In between the lot of amendments, but this is the latest amendment now. It is generally believed that changes made in 2022 depart. However, it is submitted that irretrievable breakdown cases mentioned in the original Act of 1973. It is worth noting that irretrievable breakdown of marriage is the consequence of pre-existing causes. That is why, my lord, in the when this court said there was seen as many of which would include adultery, desertion, cruelty, or separation of a continuous period. In other words, I'm saying, well, these are not exhaustive of the issue of it may be noted that the UK Matrimonial Causes Act engaged very clearly that irretrievable breakdown of marriage and breakdown on account of group are interchangeable, and that these are factors into breakdown of marriage and irretrievable. Hence, a decree for irretrievable breakdown of marriage can be granted in the above circumstances as seen to exist in the marriage. Period of separation, this is my suggestion, the period of separation will include the period. And it was pointed out to me by this court that in the UK they said the period has to exist prior to the filing of proceedings. But my suggestion is, my lord, the pendency of courts having regard to the enormous delays should also be taken into consideration. Another very common indicator of breakdown of marriage by initiated proceedings under 498A if they need be good either party libel, defamation against each other, other criminal proceedings which each all of which lead to the conclusion that the marriage is broken down. All these indicators have been drawn from judgments of this court. Then, here, I deal with the fault theory. It is true that some of the statutes dealing with divorce contain provisions to the effect that it is to be satisfied that the party is not taking advantage of their own wrong. In section 23(1), it is submitted that the context of the husband either wanting a decree for restitution to defeat a claim of maintenance. In such a situation, it may be useful to look into the question whether the husband is taking advantage of his own wrong. However, in a hotly contested matter, seeking divorce on the ground of cruelty, desertion, and adultery allegations are often age. This honorable court has held that, but this can be not an interesting observation. Give me Gura versus Gura. Interesting observation, my lord. Deciding to grant or not answers the question posed to me. Decree on the ground of breakdown of marriage not be blown out of proportion or in isolation and granting a decree for the cause of the ground of breakdown of marriage. Now, my lord, that judgment can be found at page 63 of. It is the only judgment, my lord, that I found which could aid in the interpretation of section 23. Again, this, but I won't take you through the facts because there were again multiple allegations. The allegations you will find at internal page 68. I mean, the allegations and counter allegations that they were having pornographic relationships with other people, etc. Then, my lord, para 9 criminal proceedings were filed.
so then consent divorce filed, withdrawn. After that, consent withdrawn in the widow.
Yes, multiple petitions for divorce were filed. And then the indicators are at page 75, para 19. while considering the matter in detail, we find that the appellate court had not disputed the following. Marriage parties is dead and broken down. There were allegations and counter allegations between them. There were also sorts, and love is lost between them. There is a delay in the disposal of the matter. The husband has married again and has got a child. The wife has not withdrawn her consent lawfully given for a period of 18 months. The joint petition filed in the court by the parties have settled the matter, and the wife has renounced her right to claim maintenance, which the parties prayed for was only a decree for definition of marriage and mutual consent. It appears that the appellate court was not come to court with clean hands, in that he married during the pendency of the proceedings. It may be, as expressed by the appellate court, that the factor such as marriage is dead and has broken down irretrievably, that there was no chance of reunion, that there were allegations and counter allegations made by the parties, and the parties were residing separately for 13 years. Each one of the above factors by itself individually may not have photographed. This is another legal formula below that they use. Each one is not sufficient, but cumulatively they are sufficient. Here is the view that the cumulative effect of various aspects of the case in dispute will found that the marriage is dead, both emotionally and practically, and there is no chance at all of the same will survive. And a continuation of such relations is only for namesake, and that no love is lost between the parties who have been fighting like Kilkenny cats. And there is the long. Just that, yeah, that. On the interpretation of 23, I would recommend para 23.
Okay.
Para 23. We cannot do, we have not lost sight of the fact that the conduct of the husband is blameworthy in that he married a second time and got a child during, but that factor cannot be blown out of proportion. So, Milord, that answers, I hope, the question about section 23 that was posed to me. Then what do we do? We find that the party asking for divorce is at fault. Then, Milord, it is also important that before a decree is granted, an attempt should be made to reconcile. In view of the foregoing, the answers framed by this Honorable Court, as quoted here and above, may kindly be answered accordingly. However, it is submitted that before such a decree for divorce is granted on account of irretrievable breakdown of marriage, certain safeguards for the parties to the marriage, in particular the wife, are needed to be put in place.
Yes.
Sure, by this Honorable Court. A final attempt is made in reconciling. The determination is made that the marriage has been broken down. Adequate financial provision, more particularly which is just, fair, and equitable. Having regard, I will not please note that I've used the word equitable. Having regard to the various factors such as housing arrangements, so the divorced wife and children, if any, financial arrangements consistent with the standard of living to which the husband is accustomed, welfare of the children, including the housing, education, provision, marriage, medical expenses, entertainment, extracurricular activities, custody of children where such custody is not mutually agreed in the best interest of the child. And no, this is the last one I've added based on Bhagat versus Bhagat. No blame is attributed to either party as a result of the decree for divorce, which may impact future civil or criminal proceedings. Now, my lord, this is just a checklist. Now, obviously, each one of them in the matrimonial law of other countries is very highly evolved, where the statute itself deals with financial provision. And I must point out, my lord, I'll be failing in my duty if I don't point out that England does have a regime of equitable distribution of matrimonial property on the breakdown of a marriage. We don't have it. More the reason why we should be careful in putting these safeguards in place while granting such a decree. A lot of attention will have to be paid to the fact by the judges that, Lord, now there are judgments of this court and of the Delhi High Court which cast the burden on the husband to disclose his financial status. And if I may say so, my lord, in the days when black money was very common, it was impossible for a woman to prove what is the real worth of her husband. There is so much hidden wealth in this country, it's unbelievable. But my lord, my information is that after demonetization, it has gone down a little bit. The existence of
I would not pass
untaxed
judgment
money,
on that issue.
but how much it still exists.
Technology and methodology today are available to get indexes which give us a better assessment of the income of the husband. maybe returns, income tax returns, it may be other assets, ability to value those assets. Anything else?
Well, only one thing remains. I am keen on your lordships accepting the proposition that the right to marry and the concomitant analogous right to not to exit a marriage is a fundamental right. I would put it squarely under the right to life and liberty, read with the right to form associations. Well, at the end of the day, a marriage is an association. It is it is the right to affiliate.
One's fundamental rights are subject to reasonable expectations.
It is philosophy.
It's
It's going to be,
principle is fine.
whether you like it or not, it's going to be a very major issue which is going to surface in this country. In a multiplicity of situations. Not that I'm arguing proxy for anything, but I need to let you know that there are petitions pending in the court where gay people have said we also have the right to marry because it's the right to affiliate. What the court will decide is not for me to say. But this is well traversed ground.
Can we step into those domains in these proceedings? Would be difficult to. I may have my own views in it, but I can step into those domains is a little difficult because then it would be really foreclosing the opportunity in those cases of this issue being debated. And
Well, I am more interested in saying that right to divorce is a fundamental right. I am not asking you to address for the purposes of this case. For the purposes of this case, my lord, what we're looking at is there a right to divorce? What is the nature of that right?
See, there is no doubt there is a right to divorce. There is no doubt there is an enactment now for right to divorce in every position. Question is where there is a cause, and the cause may be by one person or both persons or other person. As long as people cannot live together, you are saying that they must have an opportunity to part ways and live their life.
Look, like all laws, it has to pass the test of reasonable restriction. If it's a fundamental right, then like all laws, it must pass the test of reason. If you unreasonably keep two people in a bad marriage, then, my lord, I'm sorry, the law is liable to be declared bad in law. That is why it's important to understand what exactly are we dealing with. We are dealing with intimate relationships. An intimate relationship, no degree of the court can force an intimate relationship. That I'm only arguing that you must keep that in mind. But I've got a few additional submissions. I'll finish quickly before we close for lunch. But they're already in writing. I've given a volume, and I won't take you through the literature on the subject, but there is literature. And the primary additional submission, just tell it. And those additions. The primary one is, Lord, I'm just adding one more submission, and that is the right to marry a person of your choice is a fundamental right and guaranteed under 19(1)(c), read with Article 21. Equally, is the right to divorce must be considered a fundamental right, and no unreasonable restrictions can be put on it. It is submitted that the right should be protected under 19(1)(c). It is submitted that the right of association includes two rights: the right to form expressive associations, such as unions, and the right to form intimate associations, such as marriage and familial bonds. Then, there is this judgment of the Supreme Court in Roberts, which was a very interesting judgment. A club said we'll keep out women. And the law that was passed said that you can't keep out women. And in that case, my lord, they distinguished between intimate relationships and non-intimate relationships. So they said, all right, we can force somebody to become, to take a woman as a member in a club because it's not an intimate association. But intimate associations stand on a different level. So only for that distinction between the two associations, my lord, the case is known as Roberts. It's there in the compilation.
Yes, you've given it a note on it in para 2 of your editions.
Para 2.
You already incorporated it.
That is allowed on the well-traveled ground, well-traversed ground by this court on Puttaswamy. I'm sorry. Yes, Malone, there that the summary of Roberts submitted the United States Supreme Court in Roberts, where the constitutional validity of public accommodation laws was under challenge, held that the guarantee in the 14th Amendment of the United States Constitution protected, among other things, the right to marriage, childbirth, cohabitation, and with one's relatives. Such a right would also entail the freedom to leave such intimate association. This, I suppose, is my submission. This submitted that the right to form intimate association is a part of the freedom of association at 91C of the Constitution of India. The right to enter into association has an analogous right to leave in such an association without state interference. Now, beloved, this should be modified without, there is state interference in the form of the judge, the judiciary. So therefore, my lord, I would modify it and say reasonable restrictions can be imposed on the right, but not unreasonable restrictions. And to deny a divorce on the ground of irretrievable breakdown would amount to an unreasonable restriction than the right to leave a bad marriage. Then, my lord, your lordship may go through Roberts, the full text. I point that in this volume is also literature about how bad marriages impact children. That your lordship will find
Yes, page
at page
conflict and the damaging effect.
and how bad marriages are also bad for the two parties in question. There is an article on that as well. I mean, to me, it's common sense, but then academics want research, and that's why I'm giving you the research.
Thank you.
My lord, I'm here in my capacity as amicus, and therefore I can only persuade you. Beyond that, my lord, there's nothing I can do because I'm not representing a client.
Doesn't make a difference.
But
You are still persuasive enough.
I have to say that your lordship have given me the liberty to express my point of view, but in my capacity as amicus.
Thank you.
My lord, there's no judgment of this court incidentally on what is the role of an amicus. I haven't seen it. I've been looking for it high and low.
In one sentence to make us write better. Mr. Girish, you'll begin at 2 o'clock?
Yes.
Obliged, my lord, for the patient.
After Mr. Giri finishes, I'll take about 45 minutes.
How much time will you take?
Not more than 40 minutes.
Let's try to wind up today
Very
because
I'll convince myself.
I've scheduled other constitution benches immediately after reopening. So I would like to, I anticipated only about kept 1 day's cushion.
Read from the judgments, but not from the compiled.
So Lordship would give us some time also.
On what? See, divide your time. Both are saying. Ultimately, it will be repetition otherwise.
Correct, we'll not repeat.
All of you seem to be, I've not had a different point of view. All of you seem to be on this basis that in different ways, please
Yes.
exercise this power.
Yes.
But I am going to be
Opposite.
separately to the country.
Oh,
The Lordships cannot exercise.
Oh, I'm glad my learned friend mentioned that.
no, it's at least that somebody puts a different point of view. Somebody has to put a different point of view, so we have the satisfaction of.
Definitely, because the way 142 has been used by this court, it's matter of
No,
concern.
the loose copy.
From income tax, for all kinds of matters, 142 is now being exercised. And that's a matter of great concern.
Probably on the argument about fundamental right to association and then fundamental right to get divorced, we may not be agreeable with the submission, you know. But on the question framed, you know, we would argue that yet, yes, it can be exercised, it can be molded, it can be read into the enactment. Will be our submission.
If Mr. Dave,
One,
But I try to wind up not in 30, 35
if
minutes.
you can wind up in 30,
I'll just
35
make the
minutes,
points
and
for-
similarly, Mr. Dave, if you can make an endeavor to conclude.
Minutes next.
I won't take.
I'm trying to persuade you to take 10 minutes less so that the others get it done.
I should have mentioned, just give me 2 minutes, below, delay your lunch by just 2 seconds. At 2019, page 1, just make a note of the judge. It is a case where the issue was whether voice sampling can be done.
Yes.
And one of the arguments was that this would go against the right to self-incrimination. The court rejected it. But what is important in support of my argument that it can be done under 151 is, Lord, this court actually said we can give this power to the court, to the magistrate court, para 22. That was done. So far as the second basis of the view taken is concerned, we have already expressed our opinion that what may appear to be legislative inaction, very important, but not in the light of Mr. Dave's submission. To find, no, because he's. I know you're yes, and I'm glad there's a contrary point of view because I can counter it. Well, I said, I'm here as amicus, I'm not holding a brief.
Just give a notice.
Yeah, let's speak.
Serious inroad on Article 20. And it's completely contrary to.
Okay, thank you, thank you.
My lord, I can tell you that
I-
many judgments in this court,
All I can say is
but they're judgments of the court.
You're not depriving us for lunch.
You don't tell me what to rely on, okay? What to rely on and what not to rely on. It's not your remit in this court.
Something, apart from depriving us of earlier lunch, I have a meeting also of some concern to lawyers. We will sort out that problem.
So, just, you know, your lordship will look at this judgment where, there's an interesting discussion on whether this is
We'll
legislation
read
or
through
not
the-
legislation.
We will read through the interest. Thank
Yes,
you.
please do, because it can be done.
Thank you.
Please, yes, please. Lord, I'll be brief. Except that, my lord, on two aspects, probably, my lord, what I like to comment for your lordship's acceptance, I'll mention it.
Yeah.
But the paragraphs in the judgments, my lord, the judgments are all condensed in two compilations. One which was handed over yesterday, the other which was handed over. I'll give the paragraph numbers of the judgment. Or if your lordship's feel, because there is paucity of time. Yes.
There is the purpose of this reference. I'm looking to the purpose of this.
There are three questions. Actually, only one has been dealt with.
Okay.
Yes.
There is no disagreement also on large principles.
No.
Only what we framed as the additional question.
Yes.
Our mind is the real question.
Yes. But then also your lordships have been
142 power B exercise.
Therefore, your lordships have kept in mind the situation where the honorable court is called upon to exercise it.
Correct.
Your lordship's questions, the questions it's not really taken the question as to whether the power can be given to the family court to dissolve a marriage on irretrievable breakdown of marriage. That question doesn't seem to.
The Judging Commission, you take a note of this. You may not labor on that aspect.
Yes.
Let us have, I think, this issue really, substantive issue is there anything whittling down the power of the Supreme Court under Article 1?
No, no, nothing
It's an order for, because at the end, Mr. Dave, that's the aspect that Mr. Dave speaks to say.
Yes. No, my lords, there are only two self-restraints formulated by the honorable court.
And even note of the learned Attorney General says the same thing.
Yes.
You can't exercise powers under 142.
Says, my lord, that you can't exercise a power under 142 when one contravenes any of the part 3. 2, when it goes against any substantive breach. Part 3, of course, my lord, it doesn't. But I may not come in for your lordship's acceptance. What Singh was saying, that the right to get a divorce should also be a fundamental right. I think that's pitching it a bit too high. Anyway, my lord, probably the safer route would be that it is not a matter which is engaging your lordship's attention in these proceedings. Maybe sometime later, as law progresses, and maybe when your lordships also are there
There are time for that thing is coming.
yes. Then apparently
The time for that thing is not.
yes, yes. The
Both
time,
socially, legally, politically, and anyway.
correct. Therefore, I don't think that is probably not a path where your lordships would think it appropriate to tread upon at this point in time. Otherwise, when your lordships exercise a power under 142 in this case, obviously it doesn't violate anybody's fundamental. Then, my lord, does it violate substantive provision? My lords, the section 13, which deals with the grounds for divorce under the Hindu Marriage Act. Any marriage solemnized whether before or after the commencement of this act may on a petition presented by either the husband be dissolved by a decree of divorce on the ground that the other party, my lord, when the grounds are enumerated. Now, my lord, what is also mentioned herein, including, my lords, probably a decree for judicial separation which ripens into a decree for divorce under section 13(1)(a). And, my lords, when there has been no restitution of conjugal rights between the parties for a period of 1 year or upwards after the passing of the decree for restitution of conjugal rights in a proceeding to which they were parties. These are also grounds. But textually, my lord, the law doesn't, section 13 doesn't say.
Yes, correct. Yes. That's why all this debate.
Textually, the section 13 doesn't say. No, but I also wanted to. Section 13 does not also say textually that any marriage solemnized whether before or after the commencement of this act may on a petition presented by either the husband or the wife be dissolved by a decree of divorce on the grounds enumerated hereunder and no other. I am not saying, my lords, that therefore somebody could invent a ground which does not strictly fall within the parameters of section 13 and then say that therefore a divorce could be granted on that. That's not my submission. But there is some indication, my lord, as to why an irretrievable breakdown of marriage could comment itself as a ground for granting a divorce. That is fair. But again, I'm saying that this is under Article 142, but that's a different matter when your lordships are dealing exercise of power. No, my lord, cruelty is one of the aspects of this. Divorce will have to be granted, both physical and mental. You know, the law as it stood originally was only dealing with physical cruelty per se. But later, my lord, some years and decades back, your lordship said that it will be mental cruelty also. Bhagat also, my lord, dealt with cruelty. But there is a very detailed analysis, my lord, of what could constitute cruelty, my lord, in another judgment of the song, three-judges bench.
Summer Ghosh.
Summer Ghosh. Summer Ghosh, my lord, paragraph 101 deals with it. Your lordships only have a look at it. I'll just take 2 minutes to yes. I produce a wrong Ghosh, but Ms. Mohana, fortunately, my lord, in a compilation, has produced it, and that is tag number 6. That is in 2007 4 SEC file.
Breakdown of marriage, one spouse was
But it's enough if your lordships kindly come to paragraph 101. Okay. No uniform standard can ever be laid down for guidance, yet we deem it appropriate to enumerate some instances of human behavior. My lord's got it, but I'm sorry. No, tag 6, my lord. I think the tags are things. Tag 6 is 2007 4 SEC 511. Yes. Summer Ghosh versus JR. And then if your lordships kindly come to the 546 printed or 546 of the report, para 101.
Clause 14.
Yes.
Clause 14 is the
Yes. One to clauses, my lord, deals with what could amount to cruelty, what could amount to mental cruelty. I would commend this for your lordship's time reading, my lord, later, because I don't want to take up your lordship's time in this. But small Roman 14, next page, where there has been a long period of continuous separation, it may fairly be concluded that the matrimonial bond is beyond repair. The marriage becomes a fiction, though supported by a legal tie. By refusing to sever the tie, the law in such cases does not serve the sanctity of marriage. On the contrary, it shows scant regards for the feelings and emotions of the parties. In such like situations, it may lead to mental cruelty. Therefore, my lords, it's a question of appreciation of the facts and circumstances in a case. Then, my lords, the court finds that there has been an unnecessary recalcitrance on the part of one of the spouses, in spite of the fact that there is an irretrievable breakdown of marriage, or that they have not been cohabiting for a long period of time. They have been trading allegations without substantiated or otherwise. Or there is proof to show that one of them has been indulging, my lord, in adulterous behavior. Or there are certain other grounds, my lord, which are part of the enumerated grounds under the Act. And therefore, my lords, if cruelty is made of, if otherwise, my lord, cruelty is made of, then probably, my lords, the recalcitrance on the part of the party. My lord, I'll come to the question as to whether it is cruelty made out on the part of the person who seeks to, my lord, a divorce on one of the enumerated grounds. But that's a slightly different aspect. But otherwise, my lord, if on the facts and circumstances and on an appreciation of materials it is made out, that if the marriage is irretrievably broken down, that there is no cohabitation, parties have been living separately, they have been trading allegations, and my lord, they have been living separately for a continuous long period of time, and the litigation has also proceeded to some extent. Nevertheless, there is a recalcitrance on the part of one person, one of the spouses, my lord, not to consent for a dissolution of marriage, but say that I'll hold on to it, I'll make her pay, or I'll make him or her pay for it. Let them litigate for another. Then that is one of those areas where your lordships could come in and then say, this amounts to a cruelty.
That also happens often at times.
Yes.
Where somebody feels that, okay, you have spoiled my life, I will not let you leave your life.
Correct. My lord, if it comes to that, my lord, why I respectfully submit that this may, of course, my lord, your lordships may have to elaborate on it, but that's your lordships may consider whether it is worth elaborating.
See, it's very, I don't know, speaking for myself, very difficult to think of all the innumerable
Myriad situations, you know.
which may arise, especially in an interpersonal relationship. And where exactly we should work it out. Honestly, something like 136. Can you say what ground 136 will be worked out or not? You see it and you feel this is a case for 136 or not. Some variation will occur because
Correct,
court
Lord.
sits in different benches. Not
Though the law may not be completely in favor of interference.
Similarly, where to exercise, which factual scenario? Very difficult to enumerate, give all illustrations, give all possibilities, where it should be exercised. Issue here also before us is this, according to me. Are we entitled to exercise under 142?
Your
We are
lordship,
not setting down the norms of where all we should exercise under. Either we have a right or we don't have a right.
no, my lords, the power under 142, my lord, pristine, power under 142 is not cribbed, cabined or confined by any my lord, any restraint, either flowing from the constitution or for that matter flowing from any statutory push. It's plenary in character. Lord, I'm only repeating the words that this honorable court has used in several judgments dealing with that. Part of the compilation, Lord, at least 4 judgments deal with the power under 142. But I'm not again not taking up your lordship's time. I have given the relevant paragraph numbers also. Roypa, Lord, several other cases when Premchand Gar, Union Carbide, Supreme Court Bar Association, BSP Rajana. All those, my lord, serial numbers 23, 24, 25, and 26 in this compilation deal with that. My lord, I have given the page numbers. No, my lords, therefore, there is no, it's not a case, my lord, where this honorable court would find that the power is not available. Because it's plenary in character and it's supposed to be exercised ex debito justitiae. Why would your lordships find that there is injustice? Lordships would find that there was injustice because you can't keep 2 persons who cannot say eye to eye, cannot continue in the same manner. And may not probably throw the remaining members of the family also into disarray. Lord, by compelling them, no, you can't, you don't come under any one of the straightforward parameters of any one of the enumerated grounds, and therefore we will not interfere. This is one of those classic cases where your lordships would find that what is happening is injustice, and therefore your lordships would interfere. But that would be a pristine case of exercise of power under 142. Where your lordships have given it a name, irretrievable breakdown of marriage. Lord, this I invited your lordship's attention to only because there is an argument that in 2 judgments of this honorable court, it has been said that this honorable court decides that there is an irretrievable breakdown of marriage and grants a resolution in that regard. This honorable court is actually embarking upon a judicial legislation. And that is not something which is on embarked, and therefore it should not be done. There is also another argument that while doing so, the honorable court has probably would be contravening an express provision of a substantive provision of law, which again, my lord, I don't think is correct. There is no express provision of law or statute which is being contravened when the honorable court says that, yes, this is one of those cases where there is an irretrievable breakdown of marriage, and therefore it would be better that the parties are resolved to a degree of resolution of marriage as such.
It is an area where actually the legislature and its wisdom has not created a ground. So it's absence of ground, not prohibition of.
That's right. That's it. Therefore, my lord, please put it, my lord, this I would most respectfully come on for your lordships. Accepted. In exercising the power under 142, your lordships are not contravening any exception. Obviously, your lordships are not contravening any fundamental right. Obviously not. There is no substantive provision which is being expressly contravened. And it is only in that regard, my lord, as I said, that section 13 does not speak about an exhaustive enumeration of the grounds. That is not to say that one can invent ground and then go to the court and then say. That is why, my lord, I would respectfully submit this para 14 to put it on that platform, which is discernible and textually available from a reading of section 13 of the Hindu Marriage Act. That an unusual, unjustified recalcitrance on the part of one of the parties to the marriage to cling on to it and not grant a divorce or not let the other party free, in spite of, my lord, there is an irretrievable situation of irretrievable breakdown of marriage, would probably amount to a mental cruelty, my lord, which is discernible clearly my lord, under section 13, which is one of the grounds
But page
under section
15,
13.
Which I think we don't intervene.
I don't want to live with her. She also does not want to live with me. But then I cling on to it. Why? Only, my lord, in a manner of speaking, to exact revenge on my spouse. That, my lord, probably, that conduct by itself would amount to a cruelty. And if that is sufficient, and it is up to your lordships to discern from the facts and circumstances in each case whether it would amount to a cruelty, then I would respectfully submit there is no question of contravening any provision, but your lordships are only devising a tool by which your lordships would say to do complete justice between the parties. We are saying that please part ways and go ahead and go forth in your life. You know, this is one of the aspects by which, or one of the methods by which your lordships could probably say that exercise of power under Article 142 does not really come across any, or it does not frontally assault any one of the self-restraints that your lordships have adopted for your lordship's sake in this regard. Lord, this is one aspect on which, my lord, I would respectfully submit that your lordships may kindly bestow consideration. But this is under 142. But when it comes to, my lord, the trial court or even the high court, my lord, dealing, that's the family court or the high court dealing with this, it's a slightly more tricky situation. I really don't know. My lord,
Mr. Giri, if you once accept clause number 14,
yes.
then how can you say that the trial court and the high court cannot go?
No, my lord, that's because, my lord, accepting clause 14 and then transforming itself into a ground which is discernible under.
This judgment is not under 142.
No, this judgment is not under. That's right. That's it.
So if this is the ground of cruelty,
yes, if it becomes a ground of cruelty, your lordships are.
it cannot be done under 151. 151 is purely procedural. But if this is a ground of cruelty,
Right. Your lordships are right.
Then it can be done.
Yes, my lord. I did not. It did not strike me with.
In fact, it's a long list of instances of cruelty. Paragraph 101.
Yes.
On which decree could be passed under section 13. That's what
Yes.
pre-judgment says.
Yes, because all these would translate it into
That's right.
mental cruelty.
142 is excised by us
Yes.
because sometimes this ground is not specifically taken.
Yes.
Number one. Number two,
Yes.
during the passage of litigation itself, this ground emerges.
But, my lord, in my respectful submission, that probably, my lord, would mark the distinction between an exercise of power by your lordships
Correct.
and exercise of power by the trial court or the high court. In exercising a power of granting a dissolution of marriage on the ground of irretrievable breakdown of marriage, by bringing it under the broad heading of cruelty, there has at least to be a pleading by the party concerned that I have been subjected to a cruelty for the trial court or the high court to exercise a power. But at least that caveat should be.
Mr. Giri, the difficulty in that situation is
Yes.
the quality of pleadings, the quality of evidence led by the parties at the initial stage. And when we interact with the parties in the court,
Yes.
we understand, or when the arguments are addressed before us,
Yes.
that time we understand what is the underlining, or the differences have become so much that they cannot stand each other. They can't even try and negotiate with each other. And therefore, the very fact that you ask them to sit down and talk itself is a difficult.
No, my lord, but that is probably one of the grounds on which the court would come to the conclusion that there is an irretrievable breakdown of marriage. They can't even see eye to eye on this. But that's one of the classic tests, my lord, where this honorable court has formulated. They are not even willing to talk to each other, let alone negotiate. The negotiation at that point of time is only on how much money is to be paid by one party to the other, probably on custody of children. What is non-negotiable by both the sides is that we don't want to live with each other. That is when your lordships would find that there is an irretrievable breakdown of marriage. That doesn't depend upon, my lord, that is not completely, my lord, jettison the question of fault. There could be a fault. Cruelty is one of the fault, is predicated on a fault theory. One can't completely jettison it out of question. But what I respectfully submit that, my lord, party, your lordships discerning from the facts and circumstances or the materials that emerge out of the case when it comes to your lordship's level. That this is one of those cases where irretrievable breakdown of marriage will have to be inferred. And therefore, your lordship's exercise power under 142 may not is a different matter. I'm saying that when your lordships lay down the law now, that it could also come within the broad ambit of cruelty, then I would respectfully submit that then the power of deciding that there is an irretrievable breakdown of marriage and granting a dissolution, if to be made available to the trial court or the high court, would at least require one caveat. That is one of those cases where cruelty is alleged to be one of the grounds on which the party seeks dissolution of marriage. At least that must be. Otherwise, my lord, the statutory parameters may be completely casualized.
Because if you see 23(1)(a), it has two parts.
Yes.
It says that court can pass a decree only if it is satisfied that ground exists.
Correct.
And latter part is fault.
Correct.
Therefore, there is a feeling of cruelty
Yes.
in some form.
Yes. The court cannot enter a satisfaction unless one of the party pleads, my lord, because that is also required. My lord, it would be there. It would be there.
What will be the extent of it is that's another issue.
Yeah, that's a different matter.
Ground of cruelty has to be pleaded.
Yes, but it must be there. And if it is there, and on the materials, the court is in a position to come to the conclusion that there has been cruelty made out, but then the court, then one of the part, then if cruelty made out, my lord, in view of any of the broad parameters that has been articulated here, then, my lord, I would respectfully submit, and the court finds that there is an irretrievable breakdown of marriage, the court can clearly put it under cruelty, mental cruelty, and then still grant a divorce. That is insofar as the trial court and the high court is concerned. When it comes to this honorable court, I would respectfully submit that maybe such constraints which are otherwise applicable to the high court or the trial court should be applied or not when it comes to the Supreme Court exercising powers under Article 1. Now, my lords, second question is whether the power should be exercised at all or not. It should not be exercised, or it should be exercised, my lord, in the facts and circumstances of the case. In my respectful submission, it should be exercised, my lord, in appropriate cases. And what is it, my lord? It's a repository of a power on the highest court of the land. And if the honorable court cannot exercise power under Article 142 when justice requires to do so, when, my lord, injustice is to be addressed, then, my lord, I don't think we will be paying heed to what this honorable court has held, my lord, over the years as to the final repository of power, my lord, in the Supreme Court under Article 142. That is what it has always done. We do it to do complete justice between the parties. It could be, my lord, in a fundamental rights case, it could be in a tax issue, it could be anywhere. There is no, that's what I submit, my lord, it is not cabined or confined by any other provision of law. It is treated as plenary in character. It has been held to be declaratory of the power that is vested in the Supreme Court otherwise. And therefore, my lord, it cannot be restricted in any manner. And therefore, my lords, in appropriate cases, where your lordships find that ex debitio justitiae, the parties should be directed to go their separate ways. The honorable court could interfere under Article 42. Now, my lords, this takes care of questions 2 and 3. Now, my lords, yes. Now, my lord, if your lordships kindly come to this thing, volume 1. Yes. My lord, my written submissions are at page 12 to 17. No, I'm sorry. Page 20 to 25. Question 2 at page 20, whether the exercise of such jurisdiction under Article 142 should not be made at all, or whether such exercise should be left to be determined accident. Answer now. And the third question is what your lordships had formulated, my lord, at the last hearing. That again, my lord, I have extracted. Next page, my lord, page 23. The orders are also placed on the whether the power under Article 142 of the Constitution of India is inhibited in any manner in a scenario where there is an irretrievable breakdown of marriage in the opinion of the court, but one of the parties is not consenting. That is also, my lord, I just attempted to answer your lordships. Answer that question. My lord, the first question is what could be the broad parameters for exercise of powers under Article 142. of the Constitution to dissolve a marriage between the consenting parties without referring the parties to the family court to wait for the mandatory period prescribed under Section 13B of the Hindu Marriage Act. Again, my lord, your lordships have confined it to a question of Article 142. Now, my lord, can I just read for a moment, my lord, just these 1.5 pages, and then, my lord, I'll just make a submission of that. Question 1. What could be the, I've just read the question. Then, my lord, the first part of it, I only reproduce. Lordships would have also noted that Section 13B, the analogous section under the Special Marriage Act is Section 28. Then, my lords, the first paragraph beginning at page 21. The period of 6 months mentioned in Section 13B2 is referred to as a cooling period by this Honorable Court in several judgments. Largely, this Honorable Court has held in several judgments that the 6 months period referred to in Section 13B2 need not be considered as mandatory when this Honorable Court exercises powers under Article 142 of the Constitution to dissolve a marriage. The following judgments are relevant. My lord, I have given the judgments. All of them are part of the compilation.
In fact, Mr. Giri,
Yes.
one decision takes a view that even family court can get rid of this 6.
Yes, my lord, that is the judgment by Justice Goel.
That's right.
In that Amardeep Singh
Amar-
2017. On that, your lordships may consider whether that is required or not. The powers of the Honorable Court under Article 142 of the Constitution are always exercised to justice, to complete justice between the parties. Following judgments have held as follows. I have mentioned these 4 judgments, but not all of them are part of the compilation. The Honorable Court has consistently held that the power under Article 142 is constitutionally conferred on the highest court of the land alone, and the power by itself cannot be considered as confined by any statutory provision. Nevertheless, the self-restraint advised by the Honorable Court and practiced as well as this is that direction under Article 142 cannot be in derogation of any rights under Part 3, including Article 32. It cannot be in direct contravention of any provision of a statute. In the above backdrop, it is submitted that under Article 142, the Honorable Court in appropriate cases direct a cooling period of 6 months be reduced away by declaring the dissolution of marriage to come into effect immediately, provided parties have already expressed their consent for a dissolution or do so in an appropriate way. It is submitted that such an exercise of power would obviously not be in contravention of any right available to the person concerned in the party, nor will it substantially impinge upon a substantive provision of law. This is because Section 13B1 enables the parties to move an application jointly for a dissolution of marriage, not on the fault of either of them, but on consent. This provision deals with the conferment of a right. It is substantive in character. Therefore, separation of the parties to the marriage for a minimum period of 1 year as a condition precedent for a joint petition for divorce by mutual consent will have to be treated as mandatory. Obviously, this condition would have been invariably fulfilled in any case where the Honorable Court decides to exercise power under Article 142 by granting a decree for dissolution on mutual consent. In contradistinction to subsection 1, subsection 2 of section 13B deals with procedural aspects in essence. At any rate, the prescription of 6 months has nothing to do with the conferment of a substantive right on the parties or on the jurisdiction of the court to grant a decree for divorce. In cases where the Honorable Court considers it appropriate to exercise the power under Article 142, a compliance with under section 13B2. Obviously, in such cases, parties would have been litigating over a considerable period of time, and when ultimately the matter reaches the Honorable Court and they decide to go in for a divorce by mutual consent, a further direction to again approach the family court with a petition by mutual consent. Once they render negatory, the clear intent and purpose behind the highest court of the land exercising an inherent and constitutional power to render complete justice between the parties. It is submitted that the following could be considered as a broad parameters for exercise of power under Article 142, as delineated in question 1. Parties have expressed a clear consent to put an end to the relationship. The dissolution of the marriage should, in the circumstances at the level of the Honorable Court, be accompanied by a resolution of all associated disputes. Custody. Prolongation of the list between the parties could spawn further dispute stroke litigation. The Honorable Court is convinced that there does not seem to be any possibility of repair or approach move between the parties. These are not, this is just an indication. Of course, not if your lordships feel that further conditions may have to be.
Your last sentence in clause A requires modification.
Page 23.
Let's read it.
It's not, there does not seem to be any.
Obviously, this condition would have been invariably fulfilled.
That's small b or
No,
small a.
A last sentence.
Yes. Obviously, this condition would have been invariably fulfilled in any case where the Honorable Court decides to exercise powers under Article 142. Lord, what I wanted to say, my lord, is that the minimum period of 1 year, obviously, they would have.
No, you're saying that, or you're saying.
No, consent, my lord, no.
Only on 1 year.
1 year, only on 1
1 year also can be exempted.
1 year, my lord, I am saying, my lord, 1 year, that's only to draw a distinction, my lord, between subsection 1 and subsection 2.
No, what's
No, that,
Partly, my lord, as
you're right. To that extent, you're right.
Yes, that's all what I
what
want.
you are trying to say? Even family court could condone period of 6 months, but not 1 year.
Not 1 year.
42 also.
Say that here. That's a matter on which your lordships will have to discuss.
No, that's fine.
That's not one of the questions referred, my lord, therefore I would not be able to make a submission on that. But just as a matter so that your lordship will probably be thinking about it. My submission, my lord, that power of waiving of the statute
You're right. You may be right.
of 6 months should not be conferred, my lord, on the child. That's not necessary. Why this honorable court exercises power at all? Because the parties have been litigating for a long time. And therefore, my lord, to tell them now, you go back, now that you have consented for a dissolution, you go back, then file a fresh petition for divorce. Nine, 10 SEC 4. It cannot be waived by the family court, is what is mentioned.
The point philosophy seems to be that people can be impetuous in their behaviors.
Absolutely. Absolutely.
So give them some time and they should work it out.
Correct.
Therefore, the consistent line appears to be family court can do away with period of 6 months, but not 1 year.
No, family court also. Lord, I would respectfully submit when it comes as an original proceeding before a family court, it's better to insist on that period of. Lord, it's a completely different scenario when it comes to this honorable. Parties have been litigating, my lord, for ages. And they have been litigating for ages, my lord, on consented ground, on contested grounds. Therefore, by the time they come up to the honorable court, they would have probably gone weary, my lord, of all this fighting for all these years. And then they would
Giri, once we accept that they have to be living separately or separation for a period of 1 year,
yes.
then and then they move by joint application. Sometimes they want to get on with the life.
Life.
They have to move on from the stage.
Lord, when the honorable court lays down it as a law, Lord, when the honorable court exercises power, Lord, obviously it's at this level. There wouldn't be anything rash on that. But my lord, to give that power to the family court, my lord, across the board, in all cases.
No, even that judgment qualifies in which cases power can be exercised.
Yes.
A blanket power given to the family. 2017 judgment.
Yes. Justice Goel's judgment. Yes.
So that following that judgment, cases have been decided as weak.
This is Indira Banerjee's judgment, but it is not in SEC. I just took the SEC online copy. It's a 229 and 234. Where the ladyship said, if there is no possibility of a reconciliation, there is no point in prolonging the agreement. But also made a mention, if there is a chance of reconciliation, however little, the cooling period should be ended. It's only because of that. At the initial stage of the litigation, Lord, when obviously, my lord, they have been living separated for Those are early days. It is possible that they could say, that if they remain again for a period of 6 months, possibly there are grounds of reconciliation. Maybe the family would step in. Something. Therefore, my lord, at that stage, maybe the waiver of a 6 months period. I don't know, Lord. I leave it to your lordship.
These are possibilities. There may be numerous possibilities. I've seen in Delhi Mediation Center, 2 people divorced, custody issue on, went to mediation. Mediator Sadhna Ramchandran persuaded them to live in the same house for the benefit of the child. Ultimately, she found that the parents were more at least than the party. They got remarried. Possibilities are many.
Happens, my lord, when.
That's why when I was
But,
that in the Indian system, there are many things which come from both sides, not only a union of 2 parties. In a typical scenario, there are too many people who are involved.
The only thing is when they come after the separation of 1 year, then they come. And suppose, my lord, the courts are given it's extraordinary circumstance. Courts are given, my lord, the power to waive it in every case. But, my lord, it could lead to a rash exercise of this case. That's why I submitted, my lord, this honorable court doing it is a completely different matter. To give it to the family court, my lord, lordships may consider whether it is necessary. Lord, I'm most grateful to you, lordships.
Thank you.
Rest of things, my lord. My lord, in every judgment, my lord, if your lordships would like me to do it, my lord, I'll mark the paragraph numbers. Or your lordships may permit me to give a note, giving the paragraph numbers of all those judgments which have been cited.
Yes, Ms. Mona,
Yes,
what do you want to add?
yes, two things.
So I thought let's finish this in five
I
minutes
should be asked.
so that we have a different perspective from you. So you would have
The
the benefit.
Sibyl wants to argue before me, so Lord, of course, I have to.
That he is an applicant, I
concede
said, I'm not allowing any applications, but you have your 5 minutes, you can say what you want to add. Yes, Ms. Mona.
May it please move. Lord, I have filed a written submissions.
Okay.
Your Lordship may kindly take note of that. Yes, Mr. Savla is also. This is a specially petition. Not all other matters are transfer petitions. Mine is arising out of a specially petition, out of a High Court judgment, not, and it's a specially petition refusing the grant of divorce on the ground of cruelty. Lord, I'll just inform that our client is 73 years old and fighting this litigation for 22 years. Classic example, Lord. Why this honorable, and according to us, the wife is already remarried, still contesting this list. That's what we filed about. Yes, yes, she's remarried. We filed a voter list. They may be disputing it. Nevertheless, I have filed it along with the SLP as well. I'm just informing. We are not going to merits of the matter today because your lordships are actually determining only the questions of law. Lord, I am not addressing the first issue or the second issue. I am only addressing your lordships on the third issue. However, from where Mr. Giri left, on the question of mutual consent, whether your lordships were contemplating about the giving powers to the trial court about dispensing with the 6 months, where Mr. Giri was saying that it can be only exercised by this honorable court. Anyway, it will become redundant because by the time it comes here, unless the trial court is clothed with that power of dispensing with the 6 months, by the time it travels, many of them may not even be able to travel this far, by the time it travels to this honorable court, it is more than 6 years at least, because it goes from stage to the stage. So therefore, the question of only power being exercised by this honorable court and 13B by dispensing with may not be appropriate only to decide about this honorable court. But nevertheless, that issue, I'm not addressing. I'm just pointing out this could be a difficulty in doing that. And just two things, your lordships had said in Ashok Hurra, which actually resulted in, while talking about 142, your lordship in fact clothed this honorable court with the power of curative jurisdiction as well, which arose from the Rupa Ashok Hurra, which is from the Ashok Hurra judgment, which was read out in the morning. What was held was a mutual consent was withdrawn later, which resulted in Rupa's judgment, where this honorable court has held that you had the power of even opening a review of a matter not under 32 and this not read with all these powers, which is granted this honorable court. You can even reopen a matter which is closed in a review, unless there are new grounds which are not raised, which are already raised in the review, which a certificate is given by a senior advocate. So that is also a consequential effect of powers of this honorable court, how this honorable court can extend its powers. Also, to buttress the point which one of Ms. Jaisingh's points, which I had also noted, is that the parents' patria jurisdiction of this honorable court. Your lordships are not even, like your lordship just now said, marriage is not merely between two individuals. It's also between two families coming together. There are many people involved in the question of marriage, not when the disputes arise. It is actually the families which are affected. Nobody is talking about the mental health of the child and the family members, not in the long run.
Families are affected, but families also
Intervene, and but subsequently what happens, the product of marriage, the child will not, most of the circumstances, most of the cases, there is a child.
That is always so.
Yes, so therefore, in the interest of the child also, your lordships has gone to the extent of saying, in a case where twins were there, and they were inseparable twins, where there was a PAL brought to this honorable court, parents were refusing to separate the twins. Of course, there was no medical board was ordered here. Parents did not advise, did not go in favor of that. Some good Samaritan approached this honorable court under 32, and it's a reported judgment, in 2013. This honorable court would say, even if the parents are opposing, if it comes to the welfare of the child, this court, in its parents patria jurisdiction, will go to the extent of passing such directions. So I am inviting, commending this honorable court, under 142, your lordship will combine the jurisdiction of parents patria as well, while exercising this jurisdiction under 142 to dissolve a marriage and on the ground of irretrievable breakdown. Please take that into consideration, that a child's interest and the family's interest as well is concerned as a parents patria, my lord. And thirdly, my lord, that
Your SLP is tagged with this.
it got tagged, my lord, actually. It got tagged. It got tagged.
In a way, factually also we'll have to deal with it or not?
Sorry.
It may go back to division bench.
It may have to, my lord. In fact, just let me bring this the notice of this honorable court, my lord. It is from Bombay High Court, my lord. Justice Oka is also a party to the impugned judgment, where Justice Oka would say,
After the legal issue is
legal issue, your lordship may, there are,
Only hearing of the legal issue.
yes, yes. So I'm not even going into the merits. I'm saying, in fact, irretrievable breakdown was noted.
What's your number?
No, it is 501.6, it should be today.
Now, what's the number?
Sorry, SLP to civil 32449. It's there on the written submission.
022?
032.
03249 of 2017.
No, but that's-
Sorry, the zero will not even come. Sorry.
32449.
Yeah, 32449 of 2017.
Order, just take down order in this. Think that insofar as the decision on merits of the SLP is concerned, matter will have to go before bench of two judges. But since the judgment of this, the constitution bench would have a ramification
Yes.
on that case, limited to the aspect being debated before us, the parties have been heard.
Yes.
So for the parties have been
We can hear them as America.
very good. Lead time.
Yes, Lord. However, I may be permitted to finish the address.
We have to finish, but we want to take care of that.
Yes, yes, Lord, yes, obliged. Lord. Now, kindly, my next submission, the next submission is that, as your lordships had also observed, society has evolved, but law, my lord, has not been able to catch up with the level of, my lord, the advancement that has taken place today. In fact, today, my lords, the society is contemplating a same-sex marriage. The society has already gone into live-in partner relationship, which is recognized in terms of law. But, my lord, whatever, this honorable court has been able to travel farther and faster than the legislation sometimes, my lord, like in the case of Vishaka. Your lordships passed a direction in 1997 for taking care of offences of sexual harassment in workplaces, my lord, and passed certain directions till the legislation come into place. But it took that 16 years for the legislation to come into place, my lord. So therefore, I'm only saying it's something, Save Life Foundation, where Good Samaritan notifications were in place which were not coming into operation. This honorable court has gone a step further and then passed certain directions, my lord. Now, I am inviting your lordships to go through the provision 13B, mutual consent. In 142, while exercising this jurisdiction, my lord, your lordship will be only furthering the grounds which are already enumerated, is my humble submission, because 13 contemplates certain grounds. My lord, 1A of 13 contemplates judicial separation for 1 year, and then, my lord, restitution of conjugal rights, which when it is decreed and not effected for 1 year, it gives rise to a right to go back to the court for divorce. My lord, by the time when they come here, after a restitution of conjugal decree and they keep waiting, it's more than 1 year. It's at least, my lord, 3 to 4 years of waiting. would we be advising them to again go back and then say there is a restitution of conjugal rights decree against you for 15 years, which is pending? No, now you go and file a fresh divorce petition. Lord, is it not in complete justice that your Lordship will be exercising the power under 142? So these are circumstances where, Lord, your Lordship can very well read 13B, mutual consent, which says without any ground whatsoever, two people can go to the court and then say we have got irreconcilable differences, we want to part ways. So why not this irretrievable breakdown can be extended to other grounds which are enumerated in section 13 as well. Irretrievable cannot be a ground as such, Lord, I agree. But when you read as such grounds of cruelty, desertion, or whatever instances which has taken place over a period of time, that as a bundle not forms a ground of irretrievable breakdown, which your Lordship will not then take that into consideration while exercising powers under 142, my Lord. Your Lordship may kindly see this court, my Lord, has gone to the extent of even not reading down the definition of rape by saying that a rape, whether it is committed even by a husband for a girl who is between 15 to 18, can be still considered as a rape, though that part of the legislation was read down and then it was removed, my Lord. Though the court says we are not legislating in that judgment, independent thought, Lord, Justice Lokur would write that though we are not, Justice Deepak Gupta and Justice Lokur would write, Lord, though we are not legislating, but this is actually amounting to reading it along with the POXO Act, so that to make it workable, two legislations are workable. Similarly, my lords, your Lordship will exercise your Lordship's powers to make this, Lord, what the 1976 amendment contemplated is to make divorce liberalized, which they didn't pursue thereafter, my Lord. After 76, there is a complete standstill, though there is, though two law commission reports are there, though there is an amendment bill which never saw the light of the day, there were joint parliamentary standing committee reports, my Lord, that nothing has been followed. So all that is there. So nevertheless, my Lord, your Lordships can read all these into the grounds of the divorce and, my Lord, 13B as well, and kindly take that also the parents' petri as well. Lord, today, your Lordship will also notice and take judicial notice of the fact, like Ms. Desing also said, Lord, when we talk to youth about marriage, they say it's a noose around the neck and there is no escape route when there is a problem. So therefore, they take to the root of the institution of marriage, which we are all saying that we are wanting to protect, is not getting protected only because not certain elbow rooms, like they call it, it's a fabric of the marriage is a fabric of the institution. Marriage is a great institution, which is a fabric of the society. Not that fabric doesn't need always 555 soap, it also needs a little comforter once in a while. So therefore, Lord, I think it has to be, my Lord, attended to, and your Lordships are clothed with ample powers under 142. Lord, there are certain judgments which were not read out, which I have put in my compilation, Lord. Just one judgment which is very recent, which is even said to the level of saying that, Lord, though there is no cruelty made out, still only on 142 we are exercising this irretrievable breakdown is there in the marriage, so we are exercising 142.
That we have said it has been exercised.
In Rajendran, it said over and above that, it said there is, your Lordship may kindly see that tag number 4 of my compilation. 4. Kindly see this, Lord. Tag number 4. The last few paras would very definitely say that, Lord. It follows, Lord, your Lordship judgment in Shiva Shankaran, and then it's in para 35. It would say that, that the judgment is followed. And para 33 is the 33.
They affirm the judgment but exercise 140.
Yes, ma'am. Para 33 is what they are exercising Article 142. However, they say that para 29 they are saying there is no merit at all, and therefore there is no argument that they don't sustain. They say there is no cruelty and every marriage cannot be on that ground. It can't be. Nevertheless, they find there is a subsequent marriage.
What is it?
That is this Rajendran law. And the judgment is on that marital rape. The recent judgment, I think it is today, it's pronounced today, is that, this Honorable Court says, in fact, for a girl who wants to abort in an unmarried relationship should actually extend they have interpreted it to mean it should extend to the married relationship as well, where there can be a marital rape. The right to abortion should be permitted to be exercised. So therefore, the extent of powers of this honorable court to mold the relief and to suit the circumstances and to suit the society's development. Yes, today, it's pronounced, we'll pass it on to the court. We'll pass it on.
No, it's just
Deeply obliged.
different perspective, is there a statutory bar?
And just one thing, from case to case, it can be
Yes,
exercised.
so you are opposing her in her matter, correct?
Not only on the legal issue.
You are saying it should not be granted.
I am saying that independent of the grounds, it can't be granted.
Can't be granted. So that is what.
For the irretrievable breakdown also, we'll have to fit it in one of the grounds. And there is a bar under the Family Act, the Hindu Marriage Act. Just point out, according to me, why there is a bar.
Yeah.
That this court, if there is an express bar, then this court can't grant on the ground of breakdown of marriage beyond repair, if there is an express bar. And I would treat section 23 as an express bar. So it means just 2 lines of section.
Yes.
For please. 18 proceedings, 23(1). In any proceeding under this act, whether defendant or not, or non-traverse also can't get a judgment, you have to prove your case, whether defendant or not. If the court is satisfied that any of the grounds for granting relief exist, for grounds which are mentioned in the section 13, if they exist, then only you can grant. That is one. Then there is another provision. Lordship will see, my lords, section 23, 1E. There is no other legal ground why relief should not be granted. Then, and in such a case, but not otherwise. So there is a negative aspect also.
Okay.
So not otherwise you can't grant. And my lords, in my respectful submission, if you are granting on the ground under Article 142, kindly fit into the grounds of cruelty or any other grounds which are already enumerated under section 13. And what Mr. Giri pointed out, one judgment, not following that judgment, and giving a citation, which is in my written note also, 2013, volume 5, SCC, page 2 to 6. This court held that if for any reason, if a party is not agreeing for a divorce, then in exercise of mental cruelty, it can be granted on the ground of mental cruelty.
One line, which I wanted to say is the consent of a party who is not consenting has to be inferred by their conduct, and it should be read into.
Both of you are in a prime basis, so colored by your facts. Are you there before the other?
Yes.
No, it's a short note. We have
I'm saying,
already
since the question is whether
notice there on the-
I had also filed the written submissions. Yes.
Manoj, kind permission, I'm appearing on the lead matter, Manoj. Can I just take 2 minutes to answer? Nothing, I won't repeat anything. After Mr. Sabal, if Manoj permits.
Okay.
Not more than 2 minutes. Yeah, sure.
2 minutes for you. Sybil, 5 minutes for you.
Whatever, 3, 2, 1.
I've always had the expertise of putting it very succinctly and crispy.
I try to do that, but sometimes you don't appreciate that.
I always,
I try and do it.
I always appreciate a short argument. I can be
Okay, but let's not.
Yeah. Yeah.
But there's 3 broad issues. Number 1, the real issue in a marriage which is broken is maintenance and custody. That's the real issue.
Yes.
Divorce is used, not giving divorce, is used as an instrument to ensure I get the best order on custody and the best order on maintenance. What this court needs to do is to divorce these 2 issues. These are 2 separate issues. The core issue in a marriage, if it is not working, is maintenance and custody.
No, there is another issue also in the Indian context. I have dealt with up to number of cases where sometimes I told you the women have gone as far as to say, yes, he is married another, he is a child. Then both women have equal status, but don't take away my status.
No, I'm coming to that. That's a separate issue. What I'm saying is, Malaj, in India, marriage at the inception is a social contract. Once the marriage has taken place, then it becomes a matter of choice. Now, that social contract, as my learned colleague said, involves family, it involves caste.
Many factors.
Many factors. So when you enter into that marriage, Malaj, it's part of that social contract. Now, after 3 years, 4 years, 5 years, you feel I can't live. Now, that's personal autonomy. That's choice. That's can't be wasting my life from 40 to 55. The petition for divorce. Losing my life in the process.
You were not there when Mr. Indra Jaising was there.
I'm just saying.
She said you had a choice, you could have done this when you were the law minister.
So, Manoj, therefore, the point that I'm making is there is an issue of personal autonomy and there's an issue of social contract. And therefore, that power should not be given to the trial court, that power should be exercised by you. Now, the question, how do you exercise that power? What's the procedure? Well, I dare say, to prove cruelty is almost impossible. To prove adultery is almost impossible. Well,
Many cases succeed.
no, but in the context, well, of course cases succeed, but in the context, it's very, very difficult. It carries on for years. Therefore, so Malaz, by the time you come to this court, Malaz, the marriage is over. And then you will consider it, Malaz, and the most precious.
What is the solution at
I'm coming.
public level? Because we know that all these cases are drawn. So one of the argument was, when you were not there, that if you are saying there's an irretrievable breakdown of marriage, there has to be fact finding.
Correct. I was coming.
Irretrievable.
I knew, Malaz, I was coming to that. I had three more minutes, Malaz. I'll come to that. Now, Malaz, when you divorce that, when you segregate divorce from maintenance and custody, then you can file affidavits. Now you come to the procedure. Before the trial court, the family court, saying this is what has happened, this is how he is adulterous, or this is how he is dealt with me. That response in affidavit will come, and the trial judge can come, family court can come to the conclusion that prima facie, this seems. The test has to be much lower than the test that is applied normally. Much lower. And if prima facie comes to that conclusion, that matter, the family court can't grant divorce, but it can come to that prima facie finding. That will shorten the entire process of litigation. You can come then to the High Court and come in 142 for you to grant the divorce. So please appreciate that the process is as important as anything else. If the process gets prolonged, 21 is effective. Whereas I have a case, and I've done several of them, where there is adultery. We know there is adultery. The father says, have a DNA test. Or the wife says, have a DNA test. He says, I won't have a DNA test. So then what happens? You can prove it. You know it. Where do you go? What do you do?
So Indra Jaising was saying that there has to be a structure for which she, of course, said that legislature somehow didn't take the call, which is irretrievable breakdown of marriage coupled with sharing of, we call it wealth or means between the two parties who are married. If that financial aspect is taken care of, she says she gave examples of such kind of provision elsewhere in the world, where it is always structured with a financial. So even when it didn't pass the muster in Parliament, it was because it was not coupled with a financial structure.
I beg to differ. I tell your lordships why. I beg to differ why, because if you bring in the financials with a divorce, there will never be a settlement. With one party, you'll always want. You need to say, see, maintenance has to be granted. What happens in normal courts is interim maintenance, interim custody. We'll decide the matter at the final stage, and then we'll grant custody.
It also comes to the Supreme Court.
That also comes to Supreme Court. In the meantime, people have lost their lives. So you need to evolve a procedure, which is not inconsistent with the law. That's what you need to do.
You can do much better if where you are there, some lead is taken to bring in analyze law. Is it not? I'm not talking lightly. I'm actually saying that, if a parliamentary subcommittee would debate it out, bring a law into force,
Won't happen.
it will take care of so many things.
It won't happen. Honestly, tell you, it won't happen. There are too many cross currents in society for that to happen so easily. But that's why you need to, Manas, you need to evolve a procedure consistent with Article 21 in the context of what should happen in a family court without giving that power to the family court to come to a conclusion that this marriage actually is no longer viable. Forget about breaking down. It's not a viable proposition. And you cannot allow individuals to lose their lives litigating. And remember, mothers, the child is perhaps more important than the parents. Because the children are, if the quicker divorce takes place, the quicker the children will settle. The longer the litigation, the longer for the children, it will be traumatic. So you need to evolve a procedure within the family court system, deholds maintenance and custody, because that's the key issue. That can carry on, but on a summary, like you do nowadays, mothers in commercial.
Mr. Simple, you are on this. You are completely at variance with what Mr. Singh and argued, because of the reason you just now said. You talked about diverse thought processes and diverse situations in the society. Many cases, the divorce is gets stuck up. You're right because of maintenance, but right to fair maintenance is equally important.
I agree. Manoj, I agree. Precisely the point I'm making, Manoj. That maintenance with resolution will never take place if you integrally link the divorce with the maintenance.
But they are intrinsically linked.
I am not saying no, mother. Please appreciate. I am not saying no. But if you want, mothers, see, there is a right for the woman and the man to live separately. Mother, the 1976 judgment of an English court, the judge looking, the woman was in the witness box. The judge says she's a very charming lady, wonderful lady. I don't know why you can't live with her. He said, but don't look at it through your eyes. My eyes.
I can't even relate what one litigant said to the judge.
So the point is, mother, what may seem, correct, what may seem not cruel to the judge, what may seem not cruel to the judge may seem cruel to the individual. Well, it's all completely subjective.
There is in an interpersonal relationship, there is always be a personal likes, dislikes. There is two very good human beings may not be good partners.
That's why
they can live together perfectly fine, but when they get married, there's something.
So therefore, a lower threshold. That's precisely the point I'm making. Lower threshold of proof. Lower threshold of proof, Manoj, means not a viable marriage. And that's enough to fit in with the statute. Now, because it's impossible to prove these things, and forget impossibility, the nature of litigation is such that it takes years by the time the man or the woman have lost their lives.
The unfortunate part of all litigation now.
I'm sorry?
That's the unfortunate
No,
part
but that's,
of many litigation.
here it is personal liberty and personal autonomy. There's the difference for us. Here's the Article 21 report. Because, the best years of my life, I think, 35 to 50. If you're litigating between 35 to 50 and you don't have a divorce, the end of the matter. What do you lived for? You can't get it again. So you need, Millers, in the context of 21, you need to evolve a procedure.
The Dave is not agreeing, I'm not agreeing that that's the only best part of your life. I look, post-retirement is the best part of my life.
But I'm chiefly obliged, Millers. I'll just make some signals.
Just 2 minutes.
2 minutes to you, and after that, the remaining 35, 37 minutes are for Mr. Dave.
Thank you.
I wish to address only on the issue of 6 months waiver by the family court. Now, at section 13(1)(b) has subsection 1 and subsection 2, my lords. Now, it's in Amardeep Singh's case, this honorable court has held that subsection 1 of 13(b) is a mandatory provision which requires a 1-year period, but subsection 2, my lords, is a directory provision. So therefore, my lords, in particular facts and circumstances of the case, the period of 6 months is not mandatory and it can be waived. So once it is held that it can be waived, my lords, and it's some directory provision, then, my lords, that power can be exercised also by the family courts as well as the High Court. And my lords have been careful enough to lay down the criteria or the basis on which the delay can be condoned. So it's not an unrestricted discretion. Now, let me just see paragraph 19 at page 18 in the compilation which I have handed over. Now, let's see.
Right.
Page 18, para 19.
Yes.
It's the paragraph 19. Applying the above to the present situation. Page 18, my lords, paragraph 19.
Yes.
Applying the above to the present situation, we are of the view that where the court dealing with the matter is satisfied that a case is made out to waive the statutory period under section 13B2, it can do so after considering the following. Number one, the statutory period of 6 months specified in section 13(2)(b, in addition to the statutory period of 1 year under 13(b)(1) of the separation of the parties is already over before the first motion itself. Second, all efforts for mediation, conciliation, including efforts in terms of Order 32A, Rule 3 CPC, Section 23(2) of the Act, Section 9 of the Families Courts Act, to reunite the parties have failed, and there is no likelihood of success in that direction by any further efforts, that the parties have genuinely settled their differences, including alimony, custody of child, or any other pending issues between the parties. The waiting period will only prolong their agony. So, my lords, only with these criteria is fulfilled, then this period of 6 months can be waived. So, therefore, once it is held that this provision is not mandatory and directory, then even an application for waiver of this 6 months can be entertained by the family court as well as the High Court. And these criteria have to be applied before any such application for waiver is allowed. My lords, this further criteria has been elaborated, my lords, in the judgment of 2021, Anil Kumar's case, my lords, which we, my lords, will find at page 24, para 27. Amit Kumar versus Suman Beniwal, page 24. My lords, may just have para 27. My lords, in this case,
various parameters.
that's right. So, well, it's in my respectful submission, if these parameters are applied, then it's a guided discretionary power which has been given. And therefore, even the family court or the Honorable High Court can entertain an application, and applying these criteria which are mentioned, they can condone the period of 6 months in a fit and proper case. And one more submission is that even these criteria can be applied while exercising powers under Article 142 as well, to see that whether the marriage has been irretrievably broken down or not. Even these criteria will be relevant to come to that conclusion.
Thank you.
Great.
Yes, Mr. Dal. Give us the different perspective.
But I will begin, Lord, with Lord, in all humility. Please don't misunderstand me. But Lord, one principle your Lordship's Court have, Lord, very affirmatively rooted in your jurisprudence is that, Lord, under our Constitution, nobody is imperial in imperial, not even the Supreme. And another principle that your Lordships have always, Lord, passionately advocated is that be so ever high, you are always under the law. Lord, I respectfully submit that, Lord, it's amusing to hear that being in marriage violates Article 21, as Mr. Sybil very passionately put it. Whatever, however good or bad marriage may be, marriage is a marriage, it doesn't violate Article 21. Everybody is concerned about, Lord, the delays in the family. Nobody can dispute that. So then, my Lord, every laborer must be allowed to come here directly. Every under trial prisoner must be allowed to come here directly. Every convicted prisoner who has filed appeal should be allowed to come here directly. Every litigant who is not before a civil court and languishing for 10-20 years for justice to come to him should be allowed to come here directly. But in my respectful submission, court does not decide these matters on such considerations. That's not completely outside this course. But another principle your Lordships have very affirmatively laid down is that if statute, and this is what administrative law is very beautifully put it, your Lordships have recognized in Aswala Constitution Bench judgment in 2002. If statute provides that a particular procedure for exercise of power, it shall be exercised in that manner and in no other manner. Well, that's been affirmatively. Now, in this backdrop, Lord, allow me to put it, Lord, and I will answer question number 2 straight away. Whether the exercise of such jurisdiction in Article 142 should not be made at all. Lord, in my respectful and humble submission, it should not be made at all. Lord, Articles 131, 132, 133, 134, read with 134A, and 136 have given your Lordship's Court different jurisdictions to consider different appeals, etc. etc. What it so happened that what the constitutional framers, who were what outstanding men and women, forgot to provide that having provided conferred this jurisdiction, what about the ultimate result? So, my lord, this draft was a faulty draft when it was originally, my lord, prepared by Mr. B.N. Kaul and his colleagues. What it was pointed out by none other than Mr. Allagiri Swamy, my lord, to the Constituent Assembly, that this is very, very faulty and we must find a solution to it. So, my lord, this draft was amended, and, my lord, in that draft, these words were added. The Supreme Court, in exercise of its jurisdiction, may pass any decree or make any order as it is necessary for doing complete justice in any cause or matter pending before it, and any decree passed or order made by Supreme Court shall be executable throughout territory of India. Lord, this was debated on 14th of 1947 by the drafting committee, and ultimately Dr. Ambedkar, when he presented the draft, he said that yes, this is important, and that's how was born Article 118, which corresponds to Article 140. Sadly, Lord, the Constituent Assembly debates are completely silent on 180. Not a whisper about it. I have gone through the entire debates. Now, Lord, that's why 142 is not an independent power. 142 is a power in aid of Supreme Court's powers under 131, 132, 133, 134A and Lord 136. And it is in that context your lordships have viewed it. Now, Lord, see two judgments and your lordships, it will become very clear. Lord, kindly turn first to, Lord, I must first begin by, and don't turn to this judgment, Mr. Librarian, don't give this. 1986, just kindly note, and this is what worries me the most, because Lord, recently your lordship's judgment in an income tax case has revived 90,000 show cause notices which had abated because section 148 was deleted and new section 148A was inserted. Now, however, Lord, laudable the object behind the judgment may be, Lord, these are matters which create, Lord, extraordinary situation. The judgment which Ms. Jaising cited last, Lord, of Justice Gogoi, which says voice samples can be taken, is in teeth of a judgment of your Lordship's Court in Selby's case, where I was assisting the court as amicus. And your Lordship's Court came to the conclusion after a detailed debate hearing every Lord state and the Solicitor General, late Mr. Ghulam Mohanuddin, to conclude, Lord, and accepted my submissions that narco-analysis test, brain mapping test, and what was it? The three tests, Lord, and narco-analysis, and the three tests which could not be compulsorily administered to the accused, and Lord, that would violate Article 20, subarticles. Following the Lord, long line of judgments of your Lordship's Court in MP Sharma, Kati Kalu, and Nandini Satpathy cases. And Lord, at that time, I must tell your Lordships, Lord, the court was actually extremely concerned about the Lord, law and order situation in the country, especially not dealing with terrorism. And the court asked me repeatedly when I began at the end that, Mr. Dave, why should we not have, how do we fight terrorism? And Lord, I opened my arguments by reading a judgment of the Constitutional Court of Israel, in which, Lord, similar methods to extract, Lord, information and confession on Palestinian prisoners was, Lord, subject matter of challenge. The Israeli Supreme Court said that however much it is a question of very existence of Israel, this court cannot forget and forgo basic human values. And we will not allow these methods to be adopted by our security agencies. And that, Lord, led to, Lord, thinking on the part of the bench, Chief Justice Balakrishnan, Justice Ravindran, and Justice Panchal. And Lord, ultimately, by a very beautiful, that judgment is really very extraordinarily well considered. Lord, in 2010, Lord, just note down, 2010, 7 Supreme Court cases, 263. Where your Lordships, Lord, now, Lord, these are issues. Now, Justice Gogoi's Lord bench does not consider this judgment and has come to the conclusion that yes, the law is silent, therefore we will allow our courts to take voice samples of the accused. Lord, it completely negates the basic principles of criminal jurisprudence, burden of proof on the prosecution, right to remain silent, which is sacrosanct. Now, Lord, I respectfully submit that therefore your Lordship should not be guided by these equitable considerations. Lord, everybody is concerned about pendency. A laborer who's been waiting for 25 years to get reinstatement and back wages is as much concerned. His Article 21 is more seriously violated. Somebody in marriage who's now not wanting a divorce. So, Lord, these are extraordinary. Yes, these are challenges. But I would, Lord, beseech your lordships not to be not to be influenced by the fact that, Lord, ultimately these parties who have entered into marriage and, Lord, are unable to now live together, Lord, they must separate as quickly, and therefore this court must exercise extraordinary power. In fact, their power does not exist, as your lordships have said. And Lord, that is what I will make it good. Now, Lord, in this judgment, 1986, two Supreme Court cases, Lord, page 666, para 10, don't turn to it. But Lord, this is a warning which I have always, Lord, reminded myself about whenever I, Lord, want to argue a case where I need, Lord, extraordinary relief from the court. Sri Venugopal suggested, Lord, this is very important, para 10. This was a question of not students who were admitted to a medical college and excess of quota. College was not recognized. Mr. Venugopal said that therefore you use your extraordinary powers and now allow them to continue. This is what said. Sri Venugopal suggested that we might issue appropriate directions to university to protect the interest of the student. We do not think that we can possibly accede to the request made by Sri Venugopal on behalf of the students. Any direction of the nature sought by Sri Venugopal would be in clear transgression of the provisions of the University Act and regulations of the university. We cannot, by our fiat, direct university to disobey the statute to which it owes its existence and regulations made by university. We cannot imagine anything more destructive of the rule of law than a direction by this court to disobey the laws. Now, Lord, that's precisely what is being sought from your lordships. And it was, now please see, 61 Supreme Court. From what I said, Lord, the 61 Supreme Court was an interesting case. Lord, this is that K.M. Nanavati case, famous, Lord, your lordships are aware. But one passage clearly signifies why this, Lord, vacuum in giving Supreme Court actual powers to grant reliefs in appeals that it is going to hear. Lord, how it came about and what is the purpose of that. Just one paragraph, your lordships will not see. Kindly turn. Para 19, right column, right page. Not para 19 begins on the left side.
Yes.
But on the right side, not just after the quotation. It is noteworthy that the reprieve granted in that case covered only the period until the grant or refusal of petition for leave to appeal and did not go further so as to cover the period of pendency of the appeal of Privy Council. Unlike the order now impugned in this case, the power which was vested in the Crown to grant special leave to appeal to convicted persons from India has now been conferred on this Crown under Article 136. The power under Article 136 can be exercised in respect of any judgment, decree, determination, sentence, or order in any cause or matter passed made by any court or tribunal in territory of India. This wide and comprehensive power in respect of any determination by any court or tribunal must carry with it the power to pass orders incidental or ancillary to the exercise of that power. Hence, the wide powers given to this court under Article 142 to make such order as is necessary for doing complete justice in any cause or matter pending before it. So, Lord, 142 is squarely related to 136. It's not independent power as has been understood or with Lord great humility misunderstood so far. Now, this one was made amply clear by your lordship's court in Premchand Garg, Constitution Bench. Lord, their rule of your lordship's court framed under Article 145 was challenged, which said that in respect of matters involving fundamental rights under Article 32, costs can be imposed by your lordship's court. That was challenged. Your lordship said it's unconstitutional. In deciding that, your lordship said, the Solicitor General said, but you have powers under 142. Why can't you exercise powers under 142? And to that, your lordships interpreted 142 and answered. Kindly, this judgment requires little detail here, reading. This is 1963 Supplement Supreme Court Report 885. But Justice Gajendra Gadkar speaking for the court, Lord gave a beautiful Lord, exposition.
It's there in the compilation.
Justice Shah was Lord.
It's there in Mr. Giri's compilation also.
दुबे ने कोई नोट नहीं दिया.
Page 235.
So the way you haven't given any note.
No. I do not at the end of my argument. Generally, I like to give because I don't like to give something that I have not argued. I only confine myself to what I have actually placed before your lordships. It's not fair to the court to not put everything and then not even deal with it. Or sometimes we give submissions and put in it what we have not argued. For that, I think is a little. Now, Lord, kindly turn straight away in this judgment to page 895 first. Lord, 885, my Lord Justice Khanna.
I've got it. I've got it.
At 895. 895 first para, last 5 lines. Therefore, we do not see how it is possible to escape the conclusion retards the assertion or vindication of fundamental rights under Article 32, and in that sense must be held to contravene the said right. Lord, as Ambedkar said, that if he had to put his finger on any one provision of the Constitution, which to him was the most important, he said 32. And he bitterly criticized the original draft which was given to the Constituent Assembly framed by Pandit Nehru and his colleagues, saying that you have given rights, but you have not provided any remedy. On the first day of the Constituent Assembly, his speech is good. He was suddenly called upon by President to speak. And he told President that I thought my turn will come tomorrow. President said, no, Dr. Rajendra Prasad, please, I address today on this draft. And when he gives that, he says that what good is a constitution if it only gives rights and not give remedy? That's how was born 30 and 226. Now, please see, that's why, Lord, it's fundamental right. Now, next page, Lord, 896. It is, however, urged by the learned Solicitor General that the powers of this court under Article 142 are very wide and cannot be controlled by Article 30. He has put his argument in 2 ways. He urges that the words used in Article 142 are very wide, and since they constitute the constitutional character of this court's power, they must be very liberally construed. This contention is undoubtedly well-founded. Give me 142. 142.1 provides that in exercise of its jurisdiction, this court may pass such decree or make such order as is necessary for doing complete justice in any cause or matter pending before it. And it adds that a decree or order so made shall be enforceable throughout the territory of India in manner prescribed by any law made by Parliament, and until provision in that behalf is made in such manner as President may or by order prescribed. Solicitor General wants us to compare 142.1 with Article 194.3, and he suggests that just as powers and privileges and immunities specified by latter article are not subject to provisions in respect of fundamental right, so is the power specified. Well, those are the rights of the members of the Parliament and Legislative Assembly. The powers specified by Article 142.1 are not subject to the same rights. Then he relied upon certain judgment. Now kindly turn to next page 892. Lord, before I read that, I must read 142. And this is the crux. Supreme Court in the exercise of its jurisdiction. 142 begins with a caveat. Supreme Court in exercise of its jurisdiction may pass such decree or order. Now, if therefore, 136, 132, 133, 134, not anything else. Now, see 898. Basing himself on this decision, Solicitor General argues that power conferred on this court under Article 142 is comparable to privileges claimed by members of state legislatures under later part of Article 194.3. And so there can be no question of striking down an order passed by this court under 142.1 on the ground that it is inconsistent with Article 32. It would be noticed that this argument proceeds on the basis that order for security infringes fundamental right guaranteed by Article 32. And it suggests that Article 141, this court has jurisdiction to pass such an order. In our opinion, the argument thus presented is misconceived. In this connection, it's necessary to appreciate the actual decision in the case of Sharma and its effect. Then, your lordships go into Sharma's judgment. Now, my lord, kindly turn, last 4 lines, my lord. The position of an order made either under the rules framed by this court or under the jurisdiction of this court under Article 142(1) can be of no different. If this aspect of matter is borne in mind, there would be no difficulty in rejecting Solicitor General's argument based on 142(1). The powers of this court are no doubt very wide, and they are intended to be and will always be exercised in the interests of justice. But that is not to say that an order can be made by this court which is inconsistent with fundamental rights guaranteed by Part 3 of the Constitution. An order which this court can make in order to do complete justice between the parties must not only be consistent with fundamental rights guaranteed by the Constitution, but it cannot even be inconsistent with substantive provisions of relevant statutory laws. But Parliament has conferred the jurisdiction on district court. District court alone can exercise the powers. But under Motor Vehicles Act, for example, your lordships have given judgment, Constitution bench already arose from Mysore or somewhere, I remember, where the question was that appellate authority exercised the power of the subordinate authority. And the argument was, he is an appellate authority, he can. Your lordship said no. The power is conferred on the subordinate authority. And only subordinate authority can exercise power. Appellate authority cannot exercise that power. Your lordship's jurisprudence, Lord, in this regard is crystal clear. Your lordships have never allowed anybody to travel outside the ambit of Lord any statute. If that be so, should this court do it, Lord? In my respectful submission, no. However attractive, however your lordships may feel that people are suffering, but everybody is suffering. There are millions of litigants who are suffering. 4 crore and 80 lakh litigants are suffering. So what? The answer lies, as your lordship rightly put it to Mr. Sibal, that government has to do something to ameliorate the situation of litigation. They can't, people can't be called upon for this court to intervene in these kind of matters. It's a constitutional court. It has important issues to decide. Everybody will come here, see further. Therefore, we do not think that it would be possible to hold that 142(1) confers upon this court powers which can contravene provisions of Article 32. Then our last paragraph. That takes us to the second argument heard by Solicitor General, that Article 142 and 32 should be reconciled by adoption of rule of harmonious construction. In this connection, we ought to bear in mind that though powers conferred on this court by Article 142 are very wide, and in the same can be exercised for doing complete justice in any case, as we have already observed, this court cannot, even under Article 142(1), make an order plainly inconsistent with express statutory provisions of the substantive law, much less inconsistent with any constitutional provisions. This can therefore be no conflict between 142 and 30. Lord, in the face of this exposition, I respectfully submit that exercise of powers under 142 by your lordship's court is completely unclear. And this is really the intent, Lord, of the constitutional frameworks. Lord, let me show Lord one aspect. Give me Ambedkar as well. Lord, this, Lord,
Fun.
September 1949. Lord, please see Dr. Ambedkar warning to us. Lord, in the middle. In fact, Lord, the purpose of constitution, your lordships have got that. In the middle. In fact, the purpose of a constitution is not merely to create the organs of the state. My Lord Justice Collins.
Yes, I think.
Lordships. All your lordships have that. In fact, the purpose of the constitution is not merely to create the organs of the state, but to limit their authority. Because if no limitation was imposed upon the authority of the organs, there will be complete tyranny and complete oppression. The legislature may be free to frame any law. The executive may be free to take any decision. And the Supreme Court may be free to give any interpretation of the law. It would result in utter chaos. For these words of warning are not without justification. For this man had a foresight which was unbelievable. That's why he repeatedly warned that constitution will fail not because the draft is done, but because people will fail. And he says, I don't know what kind of people they will elect as their representatives and what will happen. Repeatedly, in every one of his speeches, Your Lordship should see the warning. He went to the extent of saying that will democracy fail? And he answers by saying, yes, if there is a landslide, there is every possibility that there will be democracy in form and not in fact. Very prophetic. Very, very prophetic. So I respectfully submit that this is how your lordships have not consistently viewed this matter. Lord, very few judgments have really gone into this. Lord Golaknath did in fact say on 142, I don't need to detail your lordship, but Golaknath was upset by Lord the larger bench judgment. So Lord Golaknath no longer is law in that sense. And only judgment which really speaks on this issue is Lord this decision of your lordships in Premchand's case. Lord, no. That is already been read. That is the man. Lord, Lord, on the citation, I'll just give the citation. Don't kindly turn to it. Mr. Librarian, kindly don't trouble lordships. But Lord, on this aspect, that Lord, when a statute prescribes a particular way that power must be exercised in that, Lord, a constitution bench judgment of your lordships is in CIT versus Anjum Aswal. 2002, 1 Supreme Court cases, 633.
2002, 1.
Supreme Court cases, 633.
It's an age-old principle. It has to be done in a particular manner. In that manner alone, it has to be.
That's it.
This was that settlement commission.
Correct. And Shiv Kumar Chadda, Lord, MCT judgment of Justice, Lord, very beautifully, Lord, he has discussed.
He who holds the procedural sword must perish with the sword.
Correct, Lord, absolutely. So, Lord, this is also, Lord, a constitution bench judgment, Daswala. So, Lord, I respectfully submit. Now, look at Lord, what is troubling me is this. Lord, please turn, for example, to the Act. It is all right, Lord. The Act, Lord, expressly provides, Lord, 13B, a particular procedure, and says, subject to provisions of this Act, a petition for dissolution of marriage by decree of divorce may be presented to the district court.
Somewhere between the file and something. I share it with them.
Copy of the section.
Yes.
13B. Subject to the provisions of this Act, a petition for dissolution of marriage by decree of divorce may be presented to the district court by both parties. So, Lord, I respectfully submit that this is a classic case where the word may is required to be interpreted as shall. Because, Lord, that's what the purpose is. Now, Lord, district court is defined in section 19, where it will go, Lord, the jurisdiction is conferred, where marriage was solemnized, or where parties reside, etc., etc. Now, Lord, what they want is, they want to substitute the words may be presented to the district court by the words may be presented to the Supreme Court. But with great respect, however Lord, strongly your lordships may feel, however compelling the reasons may be for a particular party or parties, Lord, your lordships are really opening a Pandora's box by entertaining. And I must say, Lord, Lord, where many people will be ingenious in approaching this court for many such reliefs in different jurisdictions, in different laws. So, my lord, I don't think your lordship should. Now, please see note 25. What is troubling me is this.
Mr. Dave, in section 24, where the decreeing proceedings is being said, this is not referred to district court. It's said by any court.
Not that, not any court is any district court, naturally. Your lordships are right. Because not, it depends on.
That said presentation, it says decreeing proceedings.
Your lordships are right, but not one.
Because sometimes the way the decree may not be granted. Suppose the divorce petition is dismissed. Sometimes the
Supreme Court grants.
Or Supreme Court. Then we said let the decree of divorce be granted. That's how we pass the order.
Lordship.
My only question to you is this. Looking to the limited domain of a family law principle, do you still believe, do you believe that even if parties consent, it cannot be granted? Or do you believe if parties don't consent, it cannot?
But in either case, it cannot.
They
must be relegated to the district court.
You feel only that court should be?
Yes. I'll tell your lordships why. Lord, however, Lord, modern we may be today in our approach to marriage. Lord, as they say, marriages are made in heaven. Lord, however, Lord, challenges you may have. Lord, our society, Lord, look at it this way. Your lordships have a vast experience of Western society. The reason why Western societies are breaking up because family as an institution is dying. As an institution is dying. Almost every friend that I have abroad, is divorced. Almost everybody. And their children are real sufferers. The reason why this procedure is provided is not pulling is to rethink and rethink. And in large number of cases, as your lordships might not necessarily call rightly observed, many a times couples want to get back to each other. So in a hurry, just because two of them are not wanting to reconcile, they present a petition to Supreme Court and say pass a decree under 142.
The way I told, I don't know whether you were here, that my experience of the last 5 years is a little troubling in terms of the profile of the petitions coming in, transfer petitions or otherwise which we are doing, in the time period of marriage. I felt if a data is collected, on a thumb rule, almost 50% are cases of 0 to 3 marriages. I mean, within 3 years of marriages, ostensibly the marriages are found.
But I have known of a friend who's not a dear friend whose daughter married, went on honeymoon, came back and wanted a divorce. What do you do with these children? Should the court not put a stamp on it? I mean, are these marriages so casual that not
one day, the way stumped out of after the marriage and never worked.
nothing more, and there was nothing
and
that boy did to her.
No, this is not only the troubling part is these are not only arranged marriages. They include what may be
Love
classified
marriages.
as love marriages.
Yes.
They include marriages after people have stayed together pre-marriage in a Indian context in a non-conventional way. Then married after spending a couple of years together, but still have not worked out. So there is.
Correct. I agree, my lord. But Lord, as I said, Lord, everybody look at Lord today. Your lordships have come across hundreds of cases where employers dismiss their employees without any justification. Those employees are languishing for justice for 10, 20, 30 years.
It's a different issue.
No, it's not. People can come here and say that force the employer for a settlement. Why not? I can say pass a decree under 142.
I think that's an issue of how to expedite this huge
That's-
areas and it needs, I'm always
No, I am only-
legislative challenges, it's a challenge to the legislature to debate it out.
Not
It
only,
happens.
but it's a challenge to us as an
That is why-
institution.
That is why I put it to Mr. Simple that since he occupies another position also, but he says it can't be done there.
Lord, also law minister once, a very not successful law minister. But not as an
He was not there when she attributed to him that he should have done it as law minister.
Lord, I must say, Lord, as an institution, both Lord, the bench and the bar, we both owe our citizens, Lord, speedy justice. Undoubtedly, we both owe. And your lordships have much greater responsibility because be sure that executive is not going to come to your head. It is only internal, introspection that can
Whenever
do something.
sharpening introspection takes place,
Yes.
no, you have a wide experience, nowhere in the world, as far as I know, are these volumes of litigation in courts, the government is more than a 50% litigant.
So,
No, how many, I mean, I'm not, the extreme stages of a US Supreme Court, they decide about 100 cases a year. But I would like to know any other court.
nobody,
Is
nowhere.
even able to deal with a fraction of these cases. The latter side, I used to tell once a team of foreign judges came and they sat with us on the bench when I was in the High Court. And I said, give them this dispute about direct recruits and promotees in the judicial service and let them sort this out in 1 year. You give it to them. How many judgments have come? How many views have been propounded? And some of these are perennial disputes which don't sort out.
But not with 140 crore people, our per capita ratio of judges is perhaps the lowest. The executive is not interested in it. Rule of law is failing on people are losing
Fear
faith.
of the scrutiny also.
My distinguished friend Mohana rightly says now people don't want to marry, they want to have living relationship. That's out of, it's not out of choice, it's out of compulsion because they know that if we do get married and if we do have to separate, there is no way we can separate. So, Lord, it is a very serious social challenge.
This issue of how many tiers of scrutiny should a system have? Should a revenue tier of scrutiny, I keep posing on a lighter side this before the court, should we interfere in the 7th court, the 6th court? Were there a court above us, I'm sure 50% of our orders would also be over.
Your Lordship said once, we are final not because we are final, but because we are last.
Yes.
So if somebody was above.
So I think somewhere it has to be fixed as to how many tiers of scrutiny should a particular nature of litigation go through. All of us are fallible. There's no guarantee that what we say is right.
So Lord, now just see 25, Lord, for example, 25, 2 and 3.
Yes.
Lord, why does district court retain that jurisdiction? 25, 2. If the court is satisfied that there is a change in the circumstances of either party, at any time after it has made an order under subsection 1, it may at the instance of either party vary, modify or resign any such order in such manner as court may permit. Justice. Now once you have passed an order in Supreme Court, nobody has the remedy. Nobody can do anything about it. Same with subsection 3. So if somebody remarries and the order of alimony is required to be changed, what happens? So, what I respectfully submit that, the act is a complete code. It's self-contained. In every which way, this act, yes, the delay is not because of the act. Parliament has given sufficient thought to it. The delay is because of sheer pressure, sheer population.
That's a different,
that's it.
separate problem.
Therefore, not to short circuit and say that this court should exercise powers under 142, in my respectful submission, is totally uncalled for. And I, with all humility at my command, I respectfully submit that, your Lordship should not exercise powers under 142 in this. Those are my respectful submissions. Deeply grateful.
You were saying, what if the Supreme Court says something? Just find out the data of how many reviews and how many curative petitions every week are filed on the
I agree with you.
I realize now, being party to all curative petitions, what is happening?
Lord, I must say one thing. I have only signed one, or at the instance of Legal Aid Committee. And I was never informed by Legal Aid Committee about the fate of that. It was a criminal matter, very serious matter. And it required not to be cured.
It happens. I agree.
But
party to order recently, we have allowed on a historic ground of
Your Lordship,
to restore review.
Lord, your Lordships will get a chance to preside the Legal Aid Committee of Supreme Court. Time has come when all senior lawyers should be at least given 10 matters a month. I have been begging. I was member of Nalsar for 5 years. I said that please, not one matter is sent to us. Not one matter. And I'm sure every one of us.
I had also mentioned last time to the legal aid people that they have not been actually sending regularly.
And you can't find better assistance than in Mr.
We don't mind
Ms. Mona or Ms. Vinakshi.
We should be able to utilize your offers. And there's no reason, no earthly reason, I think.
I have said repeatedly. So your Lordships may bear in mind. Soon your Lordships will be.
I'm in the Legal Service Committee.
Yes.
So that I promise some action by tomorrow.
Great.
Just one line.
Just as an aside,
And 3 colleagues of mine.
we treat them with the equal seriousness as any other brief that is given.
Absolutely.
No, just one line. Mr. Dave was pointing out 142 said in its jurisdiction. 25 is your Lordship jurisdiction. 136 is your lordship jurisdiction, 25 CPC, 406 CRPC is also your lordship jurisdiction. So all that with 142, your lordships will be coupled with that exercise. Can I have 2 minutes? Not just one thing.
Who are you for?
Amicus.
One of the amicus, but everybody's taken so much time. I have just a very small 3-line submission.
Okay.
No, I'm legally obliged.
My
1, 2, 3,
submission
yes.
primarily is that 142 is primarily akin to your old powers of equity, good conscience. Therefore, statutory law does not bind you when you exercise the power under equity and good conscience. And the words that are used in 142 is the jurisdiction of this court. Now, when my lords exercise that power under 142, the court exercises its power under one of its jurisdictions conferred under the Constitution or maybe under the statutory this thing at all. But once it is a jurisdiction of equity and good conscience under 142, then for whatever it takes to carry out that equity, deliver that equity, the court can exercise that power to meet with the ends. That is one aspect. Now, my lords, 142, the court is only bound by other provisions of the Constitution, not necessarily always the statutory, but the provisions of the Constitution itself. And number 2, it will enable the court to bypass a very cumbersome procedures in interest of justice. Because otherwise, if my lords, in a matter of a matrimonial dispute, if the parties settle here and they are relegated to go back to a trial court and to go through the procedure again, these relationships are so fragile, the settlements are so fragile that we may land up in another round of a litigation.
Both are happening. There are cases where we have settled, recorded the settlement with the schedule laid down that the first motion will be filed like the second motion will be. So both things are happening. It's a mix, but
my lords, I would clearly say that that's a power that my lords will carefully examine in each particular case. Lastly, my lords, Aaron Barrett said that where you exercise a power of equity and good conscience, and maybe in something like 142, because it's a power which is an extraordinary power, the only circumspection, because it's a matter of a restraint that the court has put upon itself. The Constitution does not prescribe any restraint on the powers of this court, whether it's only in respect of a substantive justice or that it will not cross the statutory limit. It's an exercise of restraint that the court has imposed. Now, that's where Aaron Barrett says that if you seek to exercise that restraint, then the only way to do it, provide your reasons why we have exercised that power under 142. The minute the reasons are put in there in that order, and even if it's in one paragraph, on the basis of equity, conscience, and these extenuating facts, we have exercised this power. I think everything else comes to a rest on that particular ground, my lords.
thank you.
My lords,
Thank you for providing, Mr. Dave, as
Written note of my argument by tomorrow.
as usual, you have provided without restraint a different perspective. We are happy there is one perspective. Thank you.
There are some judgments in our compilation. Please take note. Malati Ravi, which has not been read out. Not so.
One piece, a little like this.
Yes.
Start to be read.
Yes.
These judgments, after a stage, the computerization has created its own problem. These compilations get unburdened on us. Of course, we have to really segregate them and do them. But it's your short notes which work us and help us in penning down a judgment.
We have mentioned those.
Notes are
We have mentioned those in the submission.
I never believe we are professors of law. We are people who decide a list. In the shortest form we can write, the better. Thank you very much.
We have put the submissions with the judgments as well.
Yes, just one request, my lord. It's been a pleasure and a privilege to assist you. But we are also mouthpieces, my lord. There are youngsters who have also put in a lot of hard work.
Please give it. We'll convey them the copies.
Because it encourages them a lot too.
So please put down on a piece of paper.
Yes.
The amicus and the other counsels who have assisted them. Certainly, I feel it's very necessary to appreciate the younger members.
That's what I thought.
Because one of the, I don't know, your lordships may be aware, one of the rules originally framed by Supreme Court under Article 145 was, well, under the rules, one of the clauses rather, that Constituent Assembly suggested was that Supreme Court should have power to limit the arguments of lawyers. And that was removed. I have seen that.
Mr. Dave, I keep still trying it. I still keep trying.
I don't know why constitutional framers deleted it. It should have been there.
Without being restrictive, I still try to persuade lawyers.
Police board which says 3 pages.
Doctors do crack the whip sometimes, but not certain. Sometimes it goes very long because I somehow feel if it doesn't hit me in the initial time, it's not going to hit me over a couple of days.
3 pages is this court's
Can we
standard.
just tender the small submission?
3 pages. My list carries the note 3 pages.
3 pages.
It's only obliged.
We will tender.
Grateful
Grateful
to
to
you.
you.
Deeply obliged.
Deeply.
Grateful.
Thank you.